एक जानकारी और दे दूं कि हमारे जो दो ऑनरेबल स्पीकर के एड्रेस के बाद आज एक ओपन हाउस सेशन भी है, जिसमें अगर कल आप लोगों ने जो भी बातें यहाँ सुनी, जिन लोगों ने, जिन ऑनरेबल हमारे गेस्ट ने अपने व्यूज़ रखे, उससे रिलेटेड आप लोगों ने कुछ लिखा होगा, कुछ ऐसे क्वेरीज होंगे, कुछ क्वेश्चंस होंगे, तो आप सभी ने ज़रूर उसे राइट डाउन किया होगा। तो आज ओपन हाउस सेशन में आपको मौका मिलेगा कि आप भी अपनी बातें जो आपके मन में हैं वो पूछ सकते हैं, और हमारे जो ऑनरेबल डिग्निटरीज हैं वो उसका जवाब आपको देंगे। तो लगभग 1 घंटे का हमारा ओपन हाउस सेशन होगा, और उसके बाद लंच के साथ ही ये जो हमारा 2 दिन का कार्यक्रम है उसका हम विधिवत समापन करेंगे। तो आज एक बार फिर से मैं डिपार्टमेंट ऑफ होम, गवर्नमेंट ऑफ बिहार और डिस्ट्रिक्ट एडमिनिस्ट्रेशन पटना की ओर से आप सभी का बहुत बहुत अभिनंदन करती हूँ, स्वागत करती हूँ। गृह विभाग एवं जिला प्रशासन पटना द्वारा आयोजित 2 दिवसीय आयोजन हमारा नए आपराधिक कानून विषय पर ये कार्यशाला, और आज हम द्वितीय दिन यहाँ उपस्थित हैं। और जैसा कि कल मुख्य अतिथि के रूप में हमारे बीच ऑनरेबल मिस्टर जस्टिस के विनोद चंद्रन सर थे, जो चीफ जस्टिस पटना हाई कोर्ट, इसके अलावा कई हमारे ऑनरेबल जस्टिस रहे, ऑनरेबल मिस्टर जस्टिस आशुतोष कुमार पटना हाई कोर्ट, ऑनरेबल मिस्टर जस्टिस जयमाला बागची कलकत्ता हाई कोर्ट, श्री प्रशांत कुमार शाही सर ऑनरेबल एडवोकेट जनरल, इसके साथ साथ सीनियर एडवोकेट श्री बीजी हरेंद्र नाथ जो केरला हाई कोर्ट से यहाँ आए थे। हमारे बीच कल डेवलपमेंट कमिश्नर श्री चैतन्य प्रसाद सर की भी उपस्थिति थी, साथ ही साथ डीजीपी हमारे बिहार के श्री आर.एस. भट्टी सर, हमारे प्रिंसिपल सेक्रेटरी होम डिपार्टमेंट गवर्नमेंट ऑफ बिहार श्री अरविंद कुमार चौधरी सर भी मंच पर उपस्थित थे। और पूरे सेशन में ये सभी हमारे ऑनरेबल गेस्ट, जैसे ही हमारा इनॉग्रल सेशन के बाद सेशन शुरू हुए, सभी हमारे डिग्निटरीज हॉल में बैठकर पूरे दिन सभी हमारे ऑनरेबल स्पीकर्स को सुना। साथ ही साथ असिस्टेंट प्रोफेसर श्री नीरज तिवारी जी भी उपस्थित थे कल, जो नेशनल लॉ यूनिवर्सिटी दिल्ली से आए थे। इसके अलावा इस प्रेक्षागृह में, इस ऑडिटोरियम में हमारे सभी जिलों के सम्माननीय आदरणीय जिला पदाधिकारीगण थे, डीडीसी सर थे, साथ ही साथ हमारे बीच यहाँ उपस्थित थे वरीय पुलिस अधीक्षक, सभी जिलों के सत्र न्यायाधीश, सभी वरीय पुलिस अधीक्षक, इसके अलावा हमारे सभी लोक अभियोजक गण थे, जिला अभियोजन पदाधिकारी, जिला प्रशासन से जुड़े हमारे वरीय पदाधिकारी, पुलिस प्रशासन के वरीय पदाधिकारी और हमारे सभी पार्टिसिपेंट्स जो यहाँ आए हैं। तो एक बार फिर से आप सभी का मैं गृह विभाग की तरफ से, जिला प्रशासन की तरफ से अभिनंदन करती हूँ। और हमारे बीच आगमन होने जा रहा है हमारे ऑनरेबल मिस्टर जस्टिस के विनोद चंद्रन सर का, जो चीफ जस्टिस पटना हाई कोर्ट, वो सभी इधर ऑडिटोरियम में स्थान ग्रहण करने के लिए आ रहे हैं। और जैसे ही वो सभी अपनी अपनी जगह पर व्यवस्थित हो जाएंगे, स्थान ग्रहण कर लेंगे, आज का जो हमारा कार्यक्रम है उसे लेकर हम आएंगे। बहुत बहुत अभिनंदन हमारे ऑनरेबल मिस्टर जस्टिस के विनोद चंद्रन सर, द चीफ जस्टिस पटना हाई कोर्ट। वेलकम यू सर on the behalf of Home Department, Government of Bihar and District Administration, Patna. I welcome all the Honorable Mr. Justice, all Honorable dignitaries present over here, ladies and gentlemen, and all the esteemed Honorable guests present over here in the auditorium to participate in the 2 days workshop. With this quote, I would like to start today's event. If you want something you have never had, you must be willing to do something you have never done. And with this, on the dais, I would like to welcome Honorable DGP Bihar, Shri Rajvinder Singh Bhatti sir. And I would like to welcome Honorable Justice Ananya Bandhopadhyay ma'am, Kolkata High Court. And to welcome her, I would like to request Srimati K. Suhita Anupam ma'am, Special Secretary, Home Department, Government of Bihar, to present a plant, a stole, and a beautiful memento. Honorable Justice Ananya Bandhopadhyay ma'am. Welcome you ma'am. Thank you so much Srimati K. Suhita Anupam ma'am, Special Secretary, Home Department, Government of Bihar. And now we will start today's session. Our first honorable speaker needs no introduction. He has left an remarkable mark in the field of law and order. A dynamic senior-most IPS 1990 batch, known for controlling many critical cases, DGP Bihar Shri Rajvinder Singh Bhatti. I would like to request our DGP sir to address the audience present over here. Welcome sir.
A very good morning to the distinguished guests and all the participants to the second day of this workshop. I will be talking about the aspects of implementation of the 3 criminal laws, mainly from the perspective of the police. And as has been said by the speakers yesterday, there are 3-4 facets of these laws that affect policing in a big way. First is that they visualize essentially a digital criminal justice system, and that changes everything. The second is an investigation of serious crimes powered by forensics. In Bihar, at least, we are at a very low percentage of forensic use, so it is going to have a very transformative impact on investigations. The third aspect which changes for police is that it's a more transparent and a people-friendly legal framework that is visualized within this, and that also has implications for the police. As my colleague had yesterday given in the presentation, even as the new laws were notified and the 1st July deadline was announced, we had a 7-phase election in Bihar. And there was neither it was feasible and nor was it logistically even possible. So we had a window of less than a month to train about 25,000 investigators. So during the period of the elections, we worked meticulously and we selected a team of forensic scientists, legal officers, investigators, and we drafted 4 modules of training. The difference between these modules and the other trainings was that these were from an investigator's perspective and in the language that an investigator on the ground understood. And then we opted for a hybrid mode and we ran this module, 3-day module, over 4 rotations, and we could do that within less than a month. We also standardized the script to ensure that the quality of the knowledge shared was standard and there were very little variations. Now coming to the implementation parts, I will be talking about 5 areas in regard to the implementation. We all understand the new provisions regarding the obligations of the police with regard to registering crime and how it can be reported and how we have to acknowledge. So what are the changes that we have brought in to ensure that there is proper acknowledgement and registration of crime? The first is that the forms as per the new laws, whether it is the FIR, whether it is a 0 FIR, even the other forms, they have been notified and integrated with the CCTNS, which means that we are now digitally registering all the FIRs as per the new laws under the new forms. We have also uploaded on our website the email and the telephone numbers of the SHOs, SPs, and we have asked them to build a system at their level, whether at the police station or a district, to examine all these emails, electronic communication, and if a cognizable offense is made out, that must be registered. We have also set up Mahila help desks in every police station. So with regard to the obligations, with regard to wherever women are involved as victims, women are involved as complainants, to bring in that sensitivity and to bring in a systemic approach to women-related complaints. So Mahila help desks are functional in all police stations. Let me say that we haven't done this in a month. We have been working on it for the last 1.5 years. So it has just reached this point closer to the date when the implementation happened. So the Mahila help desks are now functional in every police stations. The names of the in charge of the Mahila help desk, their phone numbers have been publicly given so that women feel comfortable in reaching out to them directly, and that empathy and the sensitivity and the understanding of the Mahila help desk in charge, which is necessary for a woman to come forth and put her voice across in a policing system which is not very gender friendly to women. That is our endeavor, and I think we need to do more, but we have set the foundation for that. Very soon we are working on a single WhatsApp number where people can even give written complaints, and they will be acknowledged, and then the system will process and take action as per law. I think Karnataka is the only state which has experimented with this. We are in the process of doing that, and we will perhaps be the only state in the country which will have a single WhatsApp number, and any written complaint will be acknowledged. In order to ensure transparency, the CCTNS system, which is one of the components of the ICJS, in December 23, we had brought in digital station diaries and digital FIRs, and well before the laws came into force, our digital station diaries now ensure that the allegations with regard to manipulation and holding back station diaries, they are something that don't exist now. There's a digital time date stamp, and it ensures that every 2 hours the station diary is auto-updated. So that has reduced considerably the scope for any kind of allegations of manipulation, etc. A copy of the FIR we have ensured is given to every complainant, and we are also giving a receipt for any complaint that reaches a police station, even if there is no cognizable offense made out. 4,000 police personnel largely women, have been trained to man about 1,300 police station data centers. The future of policing rests on the CCTNS system, so the data center in each police station is at the heart of this change. And those women, they have been trained for the last 1 year, and our data centers are working well. In the last about 6 months, the government has approved and notified 284 new police stations in the state. This is the single biggest increase in police stations in the last 50 years. And along with that, 43 new police subdivisions have been notified, mostly in urban areas where due to urbanization, population increase, geographical expansion, there was a need, and the supervisory levels were highly constrained due to work pressure. So what we are looking at is roughly a citizen can physically go to a police station in 30 minutes to make him more accessible. We may be having some police stations which are closer to 45 minutes, but broadly 30 minutes is the average where any citizen can now reach a police station. Cybercrime reporting and registration was a challenge in Bihar, but the last 1.5 years we have worked, and we can absolutely say with confidence that the National Cybercrime Helpline 1930 is now receiving and recording every complaint received. In fact, the I4C, the MHA's body which monitors this and publishes the results every month, Bihar has been consistently rated the best state in recording and properly registering cybercrime complaints. And in the other parameters of seizure of various bank accounts and freezing them and all that, even there we are one of the top 10 performers now. We need to do more. We are working on that in converting more complaints into FIRs, but there is a quantum change because now we have a cybercrime police station in each district in the last about 1 year, and they have stabilized, they're working well. In fact, UP has borrowed our model and now notified a cybercrime police station in every district. We are also sensitive to making sure that the concerns of the people receive our attention, and our social media handles are now very active. In the last 1.5 years, we ensured that we have roughly 1.2 million followers on our social media handle. That makes us the top 5 in the country. And we not only post incidents, updates on that, but we are happy to acknowledge complaints, and we try to build a responsive system. We pass on these complaints down the line to try and get a sense what action has been taken and communicate to the system. So this is in terms of building a system where citizens get a proper response and acknowledgement, and his concerns are addressed. I can say with a fair degree of confidence that the complaints with regard to non-registration of crimes are almost very close to negligible. Now probably only those matters remain where there are contentious land litigation and other issues, matters of interpretation and all that, but we have made sure that the reporting of crime and the registration of crime receives the sensitivity that it deserves. The second aspect on which I would like to mention and talk about here is the crime scene investigation. What steps we have taken to make sure that the crime scene investigation are consistent with the requirements enshrined in the new laws. We have rolled out from 1st July a district mobile forensic team in every unit with whatever resources we had. We do not have sufficient at the moment, but with whatever resources we have, our district mobile forensic units are there. We have a central mobile forensic unit helpline where supposing a crime is reported, a serious crime is reported, that helpline is called and their mobile forensic unit reaches the scene of crime. And I'm happy to share that in this period of less than 1 month, we are now covering 6 times more forensic crime scenes than we ever did in the past. That too with the limited resources. Proposals to upgrade the human and the equipments and the other capacities of the forensic labs we have submitted well before the deadline, and they are under consideration of the government. Whenever that is upgraded, we have factored in the growth in crimes, the 7-year crimes for the next 5 years, and calculated how much of scientific expertise, human resource we will need, how much of various equipments we will need based on the various national standards that are in place. And based on those projections, our proposals are with the government, and we are hopeful that once they are cleared, We will have in the next few years, within definitely the 5-year timeline that the law envisages, a proper forensic capacity to handle serious crime. Meanwhile, with the existing resources that we have, we are hopeful we will roughly cover about 50% of the crimes. We have standardized an investigation kit at every police station to make sure that the collection of evidence is done scientifically. Those kits are being upgraded, may not have reached all police stations yet, but I'm thinking very soon every police station will have a functional investigation kit. And in our training that we did for the 25,000 investigators, we made sure that they were given a hands-on exposure to the investigation kit and how to use it and what to do with it. One of the big challenges that we are right now facing is the audio-video recording of the crime scene. And that is a challenge which will need two kinds of solutions. The first solution will be that we will need to equip every investigator with a smartphone. There is no other option. Our size is too big. And that proposal is under advanced stage of consideration with the government. And we are hopeful that very shortly that approval will come. Once that comes, we will roll out and make sure. We have already trained the IO, by the way, in our training, how to do that crime scene photography. So once that comes in, we will have every investigator with a smartphone and he can take that photograph. Meanwhile, we are trying to find some temporary solutions with the CD and everything, but there is a bit of a challenge there, and the permanent solution will come from that. The SOP for that, there is an SOP that the BPRND has given. We have examined that. We have drafted our own SOP with a little bit of changes, and we have shared it with our field formations. And we have sought their comments on that SOP. And within a month, I think our SOP on that will be there, and we will organize a training to make sure that it is followed and implemented effectively. One of the other things which scientific investigation foresees is the fingerprints. So the NAFIS system, which is the National Fingerprint Identification System, under the Criminal Procedure Identification Act of 2022, every person arrested has to be fingerprinted. And we have built that capacity. It has gone to the district level, but it needs to go down to the police station level. As of now, we are able to do the fingerprinting of about 25–30% of the people arrested. We are progressively increasing that. So once that happens and this NAFIS system starts functional, through the courts, the comparison between a lifted fingerprint and one in the database will happen and will be eligible and admissible as evidence in a court of law. Once the database becomes of a bigger size, the quality of the results that will come out will start improving. It will bring long-term solutions to the quality of investigations. One of the important things is about that videography and audio recording of the crime scene, searches, seizures. The BPRND has come out with the eSaksh app, and that is a very important mobile application. And there is a procedure, we have completed that, and I am hopeful within 1 week's time, we will be rolling out the eSaksh app. And then that will bring in the integrity of the digital evidence automatically, because the hash value will be auto-generated, and there will be very little scope for any kind of manipulation. So once the eSaksh app comes about, I think the question of audio-video recording will significantly improve. The third area I want to mention is about the electronic evidence. As was mentioned yesterday, that now the new laws recognize electronic evidence as primary evidence. This is a very fundamental change from investigation perspective. And we have issued a detailed police order in the first week of June, and we trained all our investigators in that with a standard operating procedure for identification, securing and collection of this e-evidence, and generating a certificate under the earlier 65B4 of the Evidence Act and the new 63(4) of the Bihar Sakshya Adhiniyam. This is fundamental to ensuring that electronic evidence is properly seized and presented before the court. That is where the question of hash value that was mentioned yesterday, to ensure the digital integrity of the digital evidence, it will be ensured through this SOP. And it is a very detailed SOP. We have even trained people. So the electronic evidence now becoming a part of our investigations and becoming a reliable piece of evidence, we have laid the foundation for that. IT investigation kit we have finalized based on the national standards, and we are going to provide one to every police station. The process is underway. Very shortly. An IT investigation kit will be there in every police station. Training of IOs to handle the electronic evidence, cybercrime aspects has also been our priority. We have encouraged our investigators, and all the new batch of sub-inspectors are being trained on the CyTrail, which is the NCRB online training for the cybercrimes. And most of our young batches, 100% in fact, if I may say, are CyTrain basic qualification they have. We are even encouraging to get to the intermediate and advanced levels. The fewer of officers are going for the intermediate and advanced levels of the CyTrain. Ultimately, we will encourage all our investigators to do that, because now the cybercrime is an integral part of even the traditional crimes. There is always some component of that in the normal crimes. So the laptop, that is also a part of our proposal to the government. Once that comes in, all this will come together in terms of actually working on the ground. An area of concern has been the issue of timelines of investigation, and that has been laid down under the law. And if I may honestly admit, this has been an area of concern even when the new laws were not in force. And the Honorable High Court has been consistently many times flagging the delays in investigation. I want to share with you what are the root causes why these delays were there, and they are actually at the heart of the problems that we face. We have taken some steps to address them, but this needs better understanding. So 1.5 years back, the number of investigators that we had was 8,700. As per the national norms, the investigators that we need based on our reporting is 27,000. So when you do not have sufficient investigators, how can you have a timeline or even a quality which is of desired standards? We have been working for the last 1.5 years. Today we have reached about 23,500 investigators. And by end of this year, hopefully we will complete the target of 27,000. We have achieved this in 2-3 ways. One, borrowing from the experience of other states for the lower threshold crimes, we have got the government to consider and approve the PTC pass constables who are fit to be ASIs and undergone the training in investigation to do those investigations. Many other states, MP, Rajasthan, have these provisions where head constables are empowered. And that was approved by the government. And then we have been consistently training 6 months all these eligible persons and then putting them into this process. Promotions was another area which was held up. We have done all the promotions, so we've got a big bulk from that. And so the numbers was our fundamental reason why all the questions about delays arose. The second reason for the delays was that, as you all know, in Bihar we have a 2-tier investigation system where the investigator investigates and a supervisory officer supervises that investigation. It's something like a check and balance. Many states don't have it, but Bihar has it. It's part of our police manual ever since time. So we modified the supervision system. In 2023, August, we reviewed the provisions of the police manual. They did give us the scope. There was earlier a 2-tier supervision system, an inspector and the SP. We brought in a 4-tier supervision system, consistent with the available provisions of the manual. The reason was very simple. Investigations got delayed because the supervisory officers were not able to supervise. And why they were not able to supervise is because the number of cases coming to them is so huge that they cannot cope up with it. So the first step that we did is we broke up the 2-tier supervision system into 4 parts from August last year. And the results are wonderful. What it has done is that it has divided the workload of supervision in 4 parts. 20% we have given to the SHOs for crimes up to 3 years punishment. And 7 years we have given it to the circle inspectors, 10 years we have given it to the STPO, beyond that is the SP and the professional crimes. And these provisions already existed in the manual. It was a question of examining and issuing that order. And now that supervision system is in place, I can tell you the number of supervisory officers has gone up from roughly 400 to 2,000 due to this decision. So Not only have we increased the number of IOs from 8,700 to 23,500, we have also increased the supervisory officer because they are the ones who take the decision in a particular case. We have increased that from roughly 400 to about 2,000. And this is what will help us match up the timelines that the law visualizes. I have still to honestly say it's going to be a challenge, but this, at least we have some foundation now to work towards that. One more thing I wanted to highlight was that that there are national norms about how many cases a particular police station should handle. There are norms about how many cases a particular subdivisional police officer should handle. We put up those norms and proposed the addition of 284 police stations, as I mentioned earlier, based on those norms. So now there are more police stations with the registration powers. So the load per police station will reduce. Second, the 43 police subdivisions will also bring in the quality and the other aspects in terms of supervision systems, and especially these are mostly in urban areas, so the quality of response to investigations and all will improve. One more challenge in these timelines as we go forward that is going to come up will be the reconciliation of the case pendency between the court and what our records say. This has been a consistent problem, and there have been discrepancies in our system. I have no hesitation in saying that. One of the ways which we had requested the Honorable High Court, and they were kind enough to consider, was to help us with giving figures of the e-court pendency on a monthly basis or something in each district. That has started to come in. Little more effort will be needed to sort of make it a more regular feature, and then we start reconciling. There is still a big gap between what our figures say and what is reflected there. But we are committed to making sure that we consistently verify everything and make sure that these two are reconciled. Ultimately, when the CCTNS system and the ICGS start working together, the legacy data is fed into it, the results will indicate the actual pendency. That's the ultimate solution. But that is still some way far. Maybe 6 months, 1 year it will take. So if the e-court systems and our pendency can reconcile, there will be no sort of case left which will be unaccountable in terms of pendency. Our initial figures will look bad. I have no hesitation in saying that. But we will come and tackle that. So when we are looking at timelines that the new laws visualize, we also have to be honest about what is the actual pendency. There will be challenges in the past, but from August 23 onwards, I have been consistently reviewing the figures. They do indicate a significant improvement. Amongst the cases registered after August 23, our speed of investigation is better. And now we have to further sharpen it with these timelines. And the investigation supervision processes have streamlined. But the legacy still remains, and it will take a little time to come out of that. I would also like to mention about the quality of investigation issues, because now the accountability of the police under the new laws and even the rights of the citizen in terms of being informed. So when we organized the training about the 25,000 investigators, we made sure that there was a particular module which catered to the quality issues. We took note of many of the observations and the directions of the Honorable High Court, particularly a judgment, it's the Om Prakash judgment, where there was very meticulously explained what's wrong and what are the faults that we have in our investigations. We taught our IOs what needs to be done. Two of the things that have been actually missing in our investigations was acknowledging the defense of a particular accused and rebutting it. So that was, I treat as a significant gap in many of our investigations. We have now streamlined that system and told our investigators to acknowledge the defense and rebut it before they come to a conclusion with regard to the investigations. So these are the changes with regard to that. Even with regard to arrest issues, we are committed to following the law, but yes, that is an area where we needed to be more stricter with our officers, that yes, arrest should not be resorted to beyond the provisions of law, but there is a certain legacy with regard to preference of arrest, as if arrest is equal to better law and order. I do not agree with that hypothesis at all. So we need to do more on that, but arrest is something we will need to watch out for and consistently make sure that our officers follow the law on that part. One of the challenges that is going to come about is that as the investigators increase, we do not have enough place where they can even sit in a police station and investigate. So in consultation with the government, we have drafted a proposal about building investigation complexes within police stations or adjacent to police stations, which will have all the facilities that the legal requirements in terms of audio-video recording, interrogation rooms, and everything that the new law envisions. So we are at the final stages of sending that to the government. So once those that facilities are created, the visualization of the law in terms of what all scientific and other inputs need to be done, how to interrogate, what should be the audio-video recording facilities available. We've done all that. Hopefully, we'll send it to the government very shortly. So the quality issues will also be linked to having the investigation complexes in place in the coming years. The Malkhan is a big challenge, and I think it concerns also the judiciary. It also concerns us significantly. Our Malkhanas are in not a good shape at all. And if I may say so, that now that we have digital evidence coming in, so it's another new challenge come up. We got a committee under the CID ADG which has submitted a report, and we are trying to understand the best practices. But building good digital Malkhanas is going to be another important concern for us, and as of now, I think we still are in the process of coming out with what exactly and how we will do it. One of the ideas on our table is to make sure that we de-link the Malkhana and bring it closer to the court. Say at a subdivision level, there can be a Malkhana, and there's a Malkhana in charge who is de-linked from the court, and he makes sure that whatever directions the court gives in terms of production, that Malkhana exhibit is produced there. And there will be modern state-of-the-art Malkhanas with all the facilities in terms of properly securing, protecting digital evidence. Lastly, I would talk about is the CCTNS program, which is an important component of the ICJS. Now, CCTS was one area where in Bihar we had lagged behind, and in the last 1.5 years we have built our CCTNS system. From a national performance percentage of 42%, we are now at 82%. We were last in the country 1.5 years back. Right now we are 23rd. Hopefully by end of this year we'll be top 10. And our integration with the ICJS is kind of 2 months away. This deadline we had to shift a little ahead. We were going to do it earlier because of the new laws. Now within 2 months there will be this 100% seamless integration with the courts. And even now, I think at least the FIRs are flowing into the courts even right now. But the complete seamless integration, and then we have been in regular touch under the guidance of the Honorable Chief Justice. They have been giving us a lot of support in trying to build a system where now even we are talking of having the e-summons and warrants. Very few states in the country have taken up the e-summons and warrants project. I met the Director General NCRB. He says we'll be ready to help. So we are looking forward to rolling out even the e-summons and warrants at the earliest possible. It just is 2 months of infrastructure. Once that comes in, we have already compiled a list of our investigators with their NIC emails, their mobile numbers, and then the summon warrants can directly flow to the investigators. And this delay and the physical mode will take away not only the delay but other kinds of malpractices that are associated with the exercise. Also, the CCTNS 2.0 is on way. As per the deliberations, the Government of India is indicating that the CCTNS 2.0 will come out very shortly. The timeline is approximately, they are saying, less than a year now. And it will all be on cloud. So the storage issues and other issues will not really be a concern. So we are preparing ourselves now for CCTNS 2.0. In the concluding remarks, I would like to once again thank the Honorable Chief Justice and the Learned Advocate General for organizing a second such conference. I have been in Bihar for a very long time, and I have rarely seen 2 such conferences happening so close together. One of the major benefits of this, apart from the discussions, is that officers of the criminal justice system get to interact with each other. And this interaction is at the heart of bringing about this change. It is the synergy between all elements of the criminal justice system which will make it work. Implementation is a challenge. There are lots of things to be done, but conferences like this help us understand each other better. And we are absolutely open to learning and improving whatever are the gaps. And we are confident that the laws will be implemented effectively. Our officers are geared up. And once again, I thank the Honorable Chief Justice and the Learned Advocate General for giving us this opportunity. Thank you.
Thank you so much, sir, for sharing your informative views with us. DGP Bihar, Shri R.S. Bhatti, sir. Thank you so much, sir. Our next honorable speaker guest present over here on the dais is Honorable Justice Ananya Bandhopadhyay. Ananya Bandhopadhyay, a member of the West Bengal Judicial Service, now posted as Additional District and Session Judge. First Court Shiliguri, next Darjeeling, is hereby transferred and posted to be the District and Sessions Judge. Uttar Dinajpur, Vice Vacant Court, last presided over by Shri Dibakar Das, elevated as an additional judge of the High Court at Kolkata on 18th May 2022, appointed as permanent judge on February 6, 2024. We are fortunate that ma'am is here with us as a speaker. May I have the pleasure to invite you for your views on the topic New Criminal Measure Act. Please, ma'am.
Honorable Chief Justice, Patna High Court, Honorable Judges of the Patna High Court, learned Advocate General, Patna High Court, brother and sister judges of the District Judiciary, the senior officials of the Patna administration as well as the police administration, distinguished guests, ladies and gentlemen, my earlier speaker, Mr. Rajendra Singh Bhatti, I would at the outset congratulate him for taking such progressive steps in the implementation of the provisions of the Act, the new laws as such. I believe yesterday there had been a robust deliberation, an exhaustive one, on the new criminal laws, and my session would be to recapitulate or to revise a part of it, since all of us are at the moment students getting ourselves acquainted to the alterations and the modifications that have been made to the existing, the edifice of the criminal acts. I would restrict my topic today to the changes in the BSA, that's Bharatiya Sakshya Adhiniyam, and its interface with BNSS. Now, to cater to the contemporary needs and the technological advancement, Bharatiya Sakshya Adhiniyam will be dealing with the broader perspective of facts and circumstances of cases by evidence, including admissibility of the electronic and digital records, which will have the similar effect and validity as well as enforceability as far as paper records are concerned, both in terms of civil jurisprudence as well as criminal jurisprudence. The earlier Act had 167 sections. BSA has 170 sections. The first section, that is short title application and commencement, has done away with the word India to make it more encompassing, so that presumably the digitally generated evidence becomes admissible, which pertains beyond the territory of India. The definitions have been incorporated in Section 2 of the BSA, and the words which have not been defined in BSA will have its source in the definitions of the Information and Technological Act, BNS, as well as BNSS. The post-independence words like Parliament of United Kingdom, Provincial Act, Crown Representative, Dominion, London Gazette, Lahore have become insignificant and redundant and have been deleted from whichsoever provisions of the Indian Evidence Act denoted the same. The words vakil, pleader, and barrister have also been deleted. The present BSA has been made applicable to court-martials convened under Army Act, Naval Discipline Act, or the Indian Navy Discipline Act, or the Air Force Act, which was not there earlier in Section 1 of the Indian Evidence Act. Now, Section 2 of the BSA defines in Section 1D the electronic and digital records. Evidence under Section 2(1)(e) includes statements given electronically. Section 3 of the Indian Evidence Act 1872 stated, documents means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of these means, intended to be used or which may be used for the purpose of recording that matter. This has been changed under Section 2(1)(d) to include the document means any matter expressed or described or otherwise recorded upon any substance by means of letters, figures, or marks, or any other means, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter, and includes electronic and digital records. Now, video recordings on mobile phones may also be qualified as documentary evidence under Section 31 of the BSA. Electronic or digital form of official gazette is also admissible as evidence. Use of law books in digital or electronic form is also admissible as evidence. Words painted, lithographed, or photographed are documents. Electronic records on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, and voicemail messages stored on digital devices are also documents. It is to be noted that in P. Gopalakrishnan alias Dire versus State of Kerala and another, the citation is 2019 HCC Online, Supreme Court 1532. In para 26 of the judgment, the Honorable Supreme Court held that the electronic record produced for the inspection of the court is documentary evidence under Section 3 of the 1872 Act. Now, Section 2(1)(e) of the BSA, which now defines the word evidence, earlier defined the word evidence in Section 3 of the Indian Evidence Act. Evidence means and includes all statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. All documents, including electronic or digital records, produced for the inspection of the court, and such documents are called documentary evidence. So here, there has been a sea change in the earlier definition of evidence. Now, oral evidence can be given electronically. This would permit the witnesses, the accused persons, and the victims to testify through electronic means, which demonstrates a technological approach which is neutral, recognizing the validity of the information given electronically as well as in person. Section 6 of the Indian Evidence Act mention facts which, though not an issue, are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. Now, Section 4 of the BSA has given a broader perspective to the same Section 6 with regards to facts in issue. It includes not only a facting issue or relevant fact, so that they are so connected to form a part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. This would lead to the inclusion of closely connected or relevant facts pertaining to the same transaction or chain of events, thus involving all possible information which were not too remote to be encompassed while dealing with the specific matter. This broadened the scope and further reduces the chance of any vital piece of evidence to be ignored, while taking into consideration the entire purview or the scope of evidence that is brought on record. The facts in issue and the relevant facts, to be termed as res gesta, was also opined by the Honorable Supreme Court in State of Maharashtra versus Kamal Ahmad Muhammad Vakil Ansari and others, cited in 2013, 12 SCC 17. Now, the next change that we can see in the BSA is in Section 22. Section 22 has the accumulation of the substance of Section 24, 28 and 29 of the Indian Evidence Act with regard to confession caused by inducement, threat or promise when irrelevant in criminal proceeding, confession made after removal of impression caused by inducement, threat or promise relevant, confession otherwise relevant not to become irrelevant because of promise of secrecy. Now, these three sections under Section 24, 28 and 29 of the Indian Evidence Act have been clubbed into Section 22, which further includes the word coercion. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, coercion or promise having reference to the charge against the accused person. Now, Section 24(2) it has an explanation. It says, consideration of proof confession affecting the person making it and others jointly tried under trial for the same offense. It says, in case when multiple people are tried jointly, if the accused who has absconded or has failed to comply with the proclamation issued against him under BNSS is absent during the trial will be conducted as a joint trial in absentia. This section is incorporated to deal with joint trial where one or more accused is tried in absentia as per Section 356 of the BNSS. In Section 35 of BSA has been broadened to the extent that the final judgment, order or decree of tribunal has also been made relevant, contrary to Section 41 of the Indian Evidence Act, where relevancy was only related to the final judgment, order or decree of a competent court. Section 39(1) of the BSA indicates the opinion of experts, broadening its horizon to other fields apart from foreign law, science and art. It includes experts from any other field along with the opinion of examiner of electronic evidence. Section 52 enumerates the facts of which the court shall take notice. It's the same, only the terms like Parliament, Admiralty, Maritime, etc., have been deleted. Section 57 dictates the primary evidence. The periphery of the primary evidence has been expanded to include digital electronic record created or stored simultaneously or sequentially in multiple files. Each file is a primary evidence. Electronic record produced from proper custody, if not disputed. Video recording simultaneously stored, broadcasted and transmitted to another device. Each of its stored recording is primary evidence. Electronic record automatically stored in a multiple storage space in computer resource. Each automated storage is a primary evidence. Secondary evidence in section 58 of the BSA, it includes the oral admissions, written admissions, and evidence provided by a person who is skilled in examining certain documents, which being technical or voluminous cannot be conveniently examined. Two important sections which requires deliberation is section 61 with regard to the electronic or digital record. It says that the digital or electronic records have the same legal effect and validity and enforceability as any other document. So the incorporation of this section 61, it does not make the admissibility more stringent, rather it makes it more convenient. Section 61 probably has been added along with the section 63 of the BSA to create more emphasis on digital records to proceed towards digitalization. The litigants who rely on secondary evidence can produce either the paper record or the digital record according to their convenience. If the section provided that only digital record is allowed or digital records will create a better impression, then the problem would have been there. Now, when both have been allowed parallelly, it reasonably cannot create any kind of a hurdle. To add more to it, the expert opinion has been included in section 39(2) of the BSA. An expert would be also the examiner of electronic evidence, which has been referred to section 79A of the Information Technology Act 2000. Now, section 63 mentions the electronic records copied in semiconductor memory shall be considered in addition to optical or magnetic media. Electronic records produced by any communication device or otherwise stored, recorded or copied in any electronic form, that is DVR, flash drive, CD, DVD, server, cloud, etc., and not produced by a computer only, as was the case in under the Indian Evidence Act, shall be considered. Computers or communication devices can be on standalone mode, on a computer system, on a computer network, on a computer resource, enabling information creation or providing information processing or storage, or through an intermediary. But certificates must be submitted along with the electronic record at each instance for admission. There are two pro forma certificates. One is Part A and one is Part B. Part A is the first certificate to be issued, signed by the person in charge of the computer or communication device. Part B, in the second schedule certificate, mandates the signature of the expert whose endorsement serves as a proof of any statement contained within the certificate. Once signed, the certificate serves as the evidentiary support of the contents of the assets. The public and private documents, they remain the same, just that the Commonwealth documents, etc., have been deleted. From the proof of other official documents, as mentioned in section 77, the expression crown, etc., has been deleted. Now, with regard to presumption as to gazettes, newspapers, and other documents, the words and the expressions London Gazette, Government Gazette, etc. have been deleted. The presumption as to electronic or digital record, presumption as to documents of 30 years of old age, presumption as to electronic records 5 years old, presumption as to electronic agreements, they are to be treated to be produced from proper custody if it is proved that the document had a legitimate origin. Under section 85, the presumption as to electronic evidence, it includes the words digital signature along with the electronic signature. The proof of cessation of territory, as it was there earlier under section 113 of the Indian Evidence Act, has been deleted. Now, section 122 of the BSA refers to the estoppel of tenants and of license of person in possession, which was earlier the estoppel of tenant and license of person in possession under section 116 of the Indian Evidence Act. Now, the present section 122 of the BSA states, no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy or any time thereafter be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. Now, the expression or any time thereafter has been added. The Honorable Supreme Court in Vasudeva versus Balkrishan, 2002, 2 SCC 50, had observed, we had an occasion to sum up the law as to estoppel of tenant and as to eviction by title paramount, and we have held the rule of estoppel between landlord and tenant enacted in section 116 of the Evidence Act has three main features. The tenant is estopped from disputing the title of his landlord over the tenancy premises at the beginning of the tenancy. Such estoppel continues to operate so long as the tenancy continues and unless the tenant has surrendered possession to the landlord, and section 116 of the Evidence Act is not the whole law of estoppel between the landlord and tenant. The principle emerging from sections 116 can be extended in their applications and also suitably adapted to suit the requirement of an individual case. Now, this term, any time thereafter, includes or infers that where one has, by his words or conduct, made it clear about the title, then the tenant, not on the remaining in the possession, the tenant will not be able to distribute the right of his landlord, saying that he had nothing in the property. The significance of this change is equitable in nature. A person cannot reprobate a fact later which he has approbated earlier. In section 124 of the BSA, where it has been mentioned who may testify, the word lunatic has been replaced by the word person of unsound mind. Section 138 of the BSA mentions the definition of an accomplice. Earlier it was in section 133 of the Indian Evidence Act. It says an accomplice shall be a competent witness against an accused person, and a conviction is not illegal if it proceeds upon the corroborated testimony of an accomplice. In the Indian Evidence Act, there was a conflict with regard to two provisions, mainly with section 114B, which stipulated that an accomplice's testimony lacks credibility unless corroborated with material particulars, while section 133 stated that an accomplice can serve as a competent witness against an accused person, and a conviction is not invalidated solely due to reliance on uncorroborated accomplice testimony. This incongruity generated uncertainty regarding the admissibility and reliability of uncorroborated accomplice testimony. The Supreme Court in Somasundaram versus State 2027 SSC 722 observed the combined result of section 133 read with illustration B to section 114 of the Evidence Act is that the courts have evolved as a rule of prudence the requirement that it would be unsafe to convict an accused solely based on uncorroborated testimony of an accomplice. The corroboration must be in relation to the material particulars of the testimony of an accomplice. It is clear that an accomplice would be familiar with the general outline of the crime, as would be one who has participated in the same. Therefore, indeed, be familiar with the matter in general terms. The connecting link between a particular accused and the crime is where corroboration of the testimony of an accomplice would assume crucial significance. The evidence of an accomplice must point to the involvement of a particular accused. It would no doubt be sufficient if his testimony, in conjunction with other relevant evidence, unmistakably makes out the case for convicting an accused. Section 138 of the BSA now reads, an accomplice shall be a competent witness against an accused person, and a conviction is not illegal if it proceeds upon the corroborated testimony of an accomplice. Therefore, the resolution of the conflict between section 114 and section 133 of the Indian Evidence Act has been addressed through section 138 of the BSA. Section 165 of the BSA states the courts are not allowed to demand production of any communication between ministers and the President of India, which has given the statutory recognition to the constitutional mandate under Article 74(2) of the Constitution of India. Section 170 of the BSA stated that the provisions of the IEA has been repealed, but pending proceedings shall continue under the repealed law. So from 1st of July 2024, the BSA provisions will be effective. Prior to that, the provisions of Indian Evidence Act will continue. I believe I have mentioned all the changes in the relevant sections as far as Indian Evidence Act is concerned. Now I will highlight certain portions of the BNSS where the audio-video electronic means and electronic communication has been incorporated for its utilization and implementation. Now, the BNSS has introduced the use of technology at all stages, from crime scene visit to investigation till trial. Now, Section 2(1)(a) of BNSS mentions the audio-video electronic means, which states it will include use of any communication device for the purposes of video conferencing, recording of processes of identification, search and seizure or evidence, transmission or of electronic communication, and for such other purposes and by such other means as the state government may by rules provide. Similarly, the electronic communication means any communication, written, verbal, pictorial information or video content transmitted or transferred by means of an electronic device, including a telephone, mobile phone or other wireless telecommunication device, or a computer or audio-video player or camera or any other electronic device or electronic form as may be specified by notification by the central government. Now, Section 54 of BNSS mentions that the accused who has been arrested can be identified through audio-video electronic means. Section 63 mentions that the form of summons can also bear the image of the seal of the court or the digital signature and can be electronically communicated. Section 64 mentions about the summons to be served electronically. Section 71 mentions the service of summons on witness. Section 94 mentions summons to produce any document or another thing, anything which has the digital evidence in it electronically. Section 105, it mentions the recording of search and seizure through video, audio, electronic means. Section 173 mentions about the electronic communication which shall be recorded by the police officer with regard to the information of cognizable offences. Section 76 mentions the procedure for investigation of any statement which can be recorded through any audio, video, electronic means, including mobile phone. Section 183 mentions the recording of confessions and statements through audio, video, electronic means. Section 185 stipulates the process of search by the police officer to be recorded through audio, video, electronic means, preferably by a mobile phone. Section 187 involves the procedure when investigation cannot be completed within 24 hours and the magistrate may extend further detention in judicial custody on production of the accused either in person or through the audio, video, electronic means, and the same has been included in the explanation. The report of the police officer on completion of the investigation through electronic communication to a magistrate under Section 193 empowers the magistrate to take cognizance of the offence based on such police report. Section 202 Section 209 and Section 2010 also mentions the nature in which the magistrates can take cognizance of offences through electronic communication. Section 227 mentions the summons or warrants may also be issued through electronic means. Section 230 of the BNSS says that the copy of police report and other documents can be furnished to the accused through electronic means or direct, that he will only be allowed to inspect if either personally or through an advocate in court. Section 231 of the BNSS mentions supply of copies of statements and documents to accused in other cases triable by the Court of Sessions in electronic form. Section 251 of BNSS says that through audio-video electronic means, the charge can be framed and the accused can be asked to plead guilty of the offence charge or not, or whether he claims to be tried. The evidence for prosecution can be recorded under Section 254 of the BNSS through audio-video electronic means. Under Section 262, through audio-video electronic means, the accused can also be discharged if the magistrate thinks fit. Under Section 265 of the BNSS, the examination of a witness may be done through audio-video electronic means and at the designated place to be notified for the state government. Similarly, for the evidence of the defense to be recorded through audio-video electronic means under Section 266 at a designated place to be notified by the state government. So proper infrastructure has to be set up by the state government for this purpose. Similarly, the evidence to be taken in the presence of the accused under 302 in similar fashion as that of Section 265 and 266. Under Section 316, it records the examination of the accused in custody through electronic communication, and his signature needs to be obtained within 72 hours of such examination. Under Section 336 of the BNSS, the evidence of public servants, experts, police officers are allowed through audio-video electronic means. Under Section 355, the provisions of inquiries and trials being held in absence of accused in certain cases where the personal attendance of the accused includes attendance through audio-video electronic means. The Section 356 of the BNSS, it mentions the inquiry, trial or judgment in absentia that I have already mentioned. Section 392 mentions that if the accused is in custody, he shall be brought up to hear the judgment pronounced either in person or also through the audio-video electronic means. Section 497 orders for the custody and disposal of property pending trial in certain cases. The court or the magistrate shall cause to be taken in the photograph and, if necessary, videograph on mobile phone on electronic media the property referred in case of disposal of any property, or the recording in a mobile phone is also considered. All trials, inquiries and proceedings under the BNSS includes issuance, service and execution of summons and warrant, examination of complainant and witnesses, recording of evidence in inquiries and trials. All appellate proceedings or any other proceedings may be held in electronic mode or by using electronic communication through audio-video electronic means under Section 530 of the BNSS. So the confluence of BSA and BNSS in terms of utilization of the audio-video electronic mode makes the recording of evidence and its admissibility easier, consuming lesser time, and of course, since as far as the expenditure is concerned, that is also lessened. I would now like to refer to certain sections of BNSS. The scope of bail and anticipatory bail. Section 2 of BNSS has been expanded to introduce new definitions for terms such as bail, bail bond, bond, electronic communication, etc. This I have mentioned earlier. Now, under Section 15 of the BNSS, the state government is now authorized to appoint as a special executive magistrate any police officer not below the rank of superintendent of police or equivalent in addition to an executive magistrate. The community service has been introduced as a form of punishment. In Section 23 of the BNSS, the power of limit of imposing fine by a magistrate of first class has been increased from rupees 10,000 to maximum rupees 50,000, and for the magistrate of second class from rupees 5,000 to 10,000. These two classes of magistrate have been also empowered to impose community service as a form of sentence. Community service has been explained as court-ordered work that benefits the community and which is not entitled to any remuneration. This provision seeks to not only decrease the prison population but also adopts a more rehabilitative and reformative approach to punishment. In Section 35(7) of the BNSS, the aged and infirm persons have been protected from arrest. It has been provided that no arrest shall be made in case of an offence punishable for less than 3 years if the person is infirm or above the age of 60 years, without prior permission of the officer not below the rank of Deputy Superintendent of Police. The rights of the aged and infirm have further been protected as witnesses under Section 179(1) of the BNSS, where no person above the age of 60 years or a person with acute illness will be required to attend at any place other than where they reside. Earlier, we have several guidelines given by the Honorable Supreme Court in Arnesh Kumar versus State of Bihar, 2014-8 SCC 273, Kartar Singh versus State of Punjab, 1994, 3 SCC 569, D.K. Basu versus State of West Bengal, 1997, 1 SCC 41. In Section 43, subsection 3 of the BSA, a specific provision has been made to provide for the use of handcuff while effecting the arrest and production before court of an arrested person who has either escaped from custody earlier or is a habitual or repeat offender in heinous offences like organized crime, terrorist act, drug-related crime, illegal possession of arms and ammunition, murder, rape, sexual offences against children, acid attack, counterfeiting of coins, currency notes, human trafficking offences against the state. Summons in electronic form, Section 63, introduces technology compatibility for issuance and service of summons. The court now can issue summons in electronic form authenticated by the image of the seal of the court or digital signature. Further, Section 70 allows for service of summons through electronic means. For the purpose of making the process effective, transparent and accountable for maintaining the register in the police station and in the court to keep the address, email address, phone number, etc. of the person to be summoned, a provision has been made in section 64 for maintaining the register in the police station and in the court to keep the address, email address, phone number, etc. of the person to be summoned. The Honorable Supreme Court, in cognizance for extension of limitation in Re 2020 N9 SCC 468, during lockdown period, had mentioned where physical delivery of legal notices, summons and pleadings is challenging, the Supreme Court allows for service through electronic means such as email, fax and popular instant messaging services like WhatsApp, Telegram and Signal. However, if using instant messaging services, simultaneous service via email on the same date was mandatory to ensure reliable communication in legal proceedings. In section 66 of the BNSS, gender neutrality has been introduced and women have been included as an adult member of the family for the purpose of service of summons on behalf of a person summoned. The earlier reference to some adult male member has been replaced with some adult member. In section 173, the provision of filing zero FIR has been introduced. Now, when information is received by the police that discloses the commission of an offence outside the limits of the police station, it shall be entered into the book to be kept by such officer. Further, the provision for lodging information through electronic communication, that is eFIR, has been added with the enabling provision that the signature of the person giving such information be taken within 3 days before the FIR is taken on record. The BNSS has introduced the right of victim to get free of cost a copy of FIR in section 173, subsection 2. The BNSS in section 173, subsection 3 has introduced the concept of preliminary inquiry in cases punishable with 3 years or more, but less than 7 years. The timeline to complete such preliminary inquiry is fixed as 14 days. Such preliminary inquiry may be conducted only with the prior permission of the officer, not below the rank of Deputy Superintendent of Police. In section 173(4), specific mention of making an application to the magistrate is introduced in the event the FIR is not registered even after the intervention of the Superintendent of Police. As far as the victims of rape are concerned, affording further protection to the same, it has been mandated in section 183(6)(a) of the BNSS that their statement shall be recorded only by a lady judicial magistrate and in her absence by a male judicial magistrate in the presence of a woman. To facilitate speedy and accountable criminal proceedings, section 184(6) provides that the registered medical practitioner shall forward the report of the examination of a victim of rape to the investigating officer within 7 days, who shall further forward it to the magistrate. This provision establishes a specific time frame for the supply of medical report and streamlines the overall process of supply of documents. The summary trial for the petty offences has been introduced under section 283 to reduce the burden on judiciary and to expedite trial processes in petty and less serious sections, which make summary trial mandatory for petty and less serious offences like theft, receiving or retaining stolen property, house trespass, breach of peace, criminal intimidations, etc. In cases where punishment is extendable to 3 years, which was earlier 2 years, the magistrate may, for the reasons to be recorded in writing, and after giving the accused a reasonable opportunity of being heard, try such cases summarily. The concept of re-bargaining has been broadened under section 293 of the BNSS, adopting a lenient and rehabilitative approach in instances involving first-time offenders where minimum punishment is prescribed, the court may impose a sentence equal to 1/4 of the minimum punishment, making a departure from the existing norm of 1/2 of the punishment. Further, in cases where the punishment is extendable and no minimum punishment is prescribed, a first-time offender may receive a sentence equivalent to 1/6 of the prescribed punishment, decreasing the quantum of punishment from the previous 1/4 standard. This provision underscores a commitment to a more progressive and individualized approach to sentencing, especially for the first-time offenders. Under Section 349 of the BNSS, it safeguards the rights of citizens and restricts the need for arrest of persons. The magistrates for the first class are empowered with this provision to direct any individual to provide specimens and/or samples without necessitating their arrest. This legal mechanism strikes a balance between the protection of individual rights and the investigative process, offering a measured approach to obtain necessary evidence without resorting to unwarranted detention. Further, the ambit of this provision is expanded by including voice samples and finger impressions within its purview. Witness Protection Scheme under Section 398 of the BNSS mandates the preparation and notification of a witness protection scheme by every state government. A witness protection scheme serves as a safeguarding mechanism, fostering an environment where witness can contribute to the legal procedure devoid of fear or duress. In Mahendra Chawla versus Union of India 2019, 14 SCC 615, the Supreme Court declared the protection witness scheme to be law until the Parliament of various state governments prepared and notified their own witness protection schemes. Although various provisions in the IPC, IEA and the CRPC recognize the vulnerabilities faced by witnesses and provide some support, the 2018 order of the Supreme Court was the first to develop a comprehensive approach towards ensuring the protection of witnesses in criminal proceedings. Under Section 472, the time-bound disposal of mercy petitions has been enumerated. It gives, the provision prescribes a time frame requiring such petitions to be filed within 30 days before the governor and 60 days before the president. The superintendent of jail is now entrusted with the responsibility of informing the convicts about the confirmation of their death sentence or the dismissal of their appeal or review of a special leave appeal. Additionally, the jail superintendent is mandated to ensure that every convict, especially in cases involving multiple convicts, submits their mercy petition within 60 days. In situations where no other petitions are received from the remaining convicts, the jail superintendent is required to forward their names, address, and the case records to the central or state government for consideration alongside the mercy petition filed. Apart from these provisions in the BNSS, the provisions which were catered to the district judiciary are the ones where the post of judicial magistrate of third class, metropolitan magistrate and assistant magistrates has now been abolished to bring uniformity in classes of courts and judges across the country. There will be 4 kinds of judges now: judicial magistrate of second class, judicial magistrate of first class, which includes chief judicial magistrate or additional chief judicial magistrate, sessions judge, including additional session judge, and executive magistrate. Consequential changes have been made to Section 8, 11, 12, 14, 72, 17, 22, 29, 113, 196, 214, 320, 321, 415, 422 and 436 of the BNSS. In the chapter on order of maintenance of wives, children and parents, an important addition has been made in BNSS Rule 2023 in section 145, wherein in case of dependent father or mother, the proceedings for order of maintenance may be initiated at a place where he or she resides. This removed the difficulty which existed in the CRPC, where in case of parents, the place of initiation of proceedings was the place of residence of their son. In section 183 now, the judicial magistrate in whose district the offence has been registered, whether having jurisdiction in the case or not, is made competent to record the confession or statement in the course of investigation. For serious and heinous offences, it has been introduced in section 183 that in cases relating to offences punishable with imprisonment for 10 years or more, or imprisonment for life or with death, the judicial magistrate shall mandatorily record the statement of the witness brought before him by the police officer. This provision adds credibility to the criminal process. Affording further protection to the victim of rape, it has been mandated in section 183, subsection 6, clause A, that their statement shall be recorded only by a lady judicial magistrate and in her absence by a male judicial magistrate in presence of a woman. To facilitate speedy and accountable criminal proceedings, section 184(6) provides that the registered medical practitioner shall forward the report of examination of a victim of rape to the investigating officer within 7 days, who shall further forward it to the magistrate. This provision establishes a specific time frame for the supply of medical reports and streamlines the overall process of supply of documents. In section 190 of the BNSS, it has been provided that if the accused is not in custody, the police official shall take security for his appearance before the magistrate, and the magistrate shall not refuse to accept the charge sheet on the ground that the accused is not taken into custody. Further, in a step to make the law more victim-centric, section 193(3) subclause 2 mandates that the police officer must inform the progress of the investigation to the informant or victim within 90 days of the investigation. Technology has been included communication for conveying this to the victim or the informant. In case the offence is committed outside India, the jurisdiction of the court where the offence is registered is also included in section 208. Further, in case of receipt of evidence relating to offences committed outside India, the depositions or exhibits may be produced in electronic form as well. In section 223, the magistrate shall grant an opportunity to the accused person to be present in the court before the court proceeds to take cognizance of an offence on a complaint. The magistrate shall now take cognizance of a complaint against a public servant arising in course of discharge of his official duties after considering his assertions and receiving a report containing facts and circumstances of the incident from his superior officer. In section 227, dealing with the issuance of summons, the summons and warrants to be issued through electronic means shall be considered. In section 230, timeline has been prescribed with respect to supply of copies of police report and other documents to the accused and the victim, which is to be made within 14 days from the date of production or appearance of the accused. In case of voluminous documents, copies may be furnished through electronic means. Similarly, in case of session tribal cases instituted on a complaint, the copies, statements and documents may be furnished through electronic means as in section 231 of the BNSS. To address delays in commitment of cases, section 232 of BNSS stipulates that the proceedings must be completed within 90 days from the date the magistrate takes cognizance. This period may be extended to 180 days with reasons recorded in writing. Further, any application filed before the magistrate by the accused of the victim shall also be forwarded to the Court of Sessions. To minimize delays and ensure a prompt trial in sessions cases, Section 250 mandates a 60-day window from the date of committal for the accused to file a discharge application. Additionally, Section 251 reinforces this effort by setting a 60-day timeline for framing charges for the first hearing on charge. To enhance efficiency, the use of audio-visual means to communicate and explain the charges to the accused person is introduced under Section 251(2). To expedite criminal proceedings using technology, Section 254 allows the use of audio-video electronic means in a sessions case for the deposition of evidence or statements of witnesses, police officers, public servants, or experts. A similar provision is included in Section 265 for the trial of warrant cases, enabling the use of electronic documents for examining witnesses. In Section 265 and 266, which deal with the evidence of prosecution and for defense, if the attendance of the prosecution witness cannot be secured under Section 269(7), despite giving opportunity and after taking all reasonable measures, it shall be deemed that such witness has not examined for not being available, so that the magistrate may close the prosecution evidence and proceed with the case on the material on record. Under Section 272, in a case instituted on a complaint, if the complainant remains absent even after giving 30 days notice, the magistrate is empowered to discharge the accused. It is aimed to reduce delays in complaint cases and limit the scope of false and frivolous complaints. In a nutshell, I believe I will now conclude whatever I could have deliberated upon the provisions of the BSA and the BNSS. I am grateful to the Chief Justice, Patna High Court, as well as the Advocate General for giving me this opportunity to be here amongst with you. And I believe the stakeholders involved will apply the provisions and implement the same, so that the objective of the new criminal acts will fructify and will cater to the demand of the technological advancement and be useful for the litigants, the accused, the victims at large. Thank you.
Thank you so much, ma'am, for sharing your thoughts and information regarding the topic. Hope you all had a great experience, as every experience is meant to teach you something new. In this 2 days workshop, we have gained insights for our honorable speakers. And now, it's time for a deeper conversation with an open house session. And for this, I would like to invite all our honorable dignitaries on the dais, Honorable Mr. Justice K. Vinod Chandran sir, the Chief Justice Patna High Court, Honorable Mr. Justice Ashutosh Kumar, Patna High Court. You all are requested to please come on the dais to take your seats. Honorable Justice Ananya Bandhopadhyay Ma'am, Kolkata High Court. Shri Prashant Kumar Shahi Sir, Honorable Advocate General. Shri B.G. Harindranath, Honorable Senior Advocate. Chief Secretary of Bihar, Shri Brajesh Mehrotra Sir. Shri Rajvinder Singh Bhatti Sir, Honorable Director General of Police, Bihar. Shri Arvind Kumar Chaudhary Sir, Principal Secretary, Home Department, Bihar. Shri Brighu Srinivasan Sir, Director, Bihar Police Academy, Rajgir. And Shri Neeraj Tiwari, Assistant Professor, NLU, Delhi. You all are requested to please come on the stage to take your seats. Our honorable dignitaries, I welcome you all once again on the dais. Before we start our open house session, I would like to request Shri Pranab Kumar Sir, Secretary, Home Department, to welcome our Chief Secretary of Bihar, Shri Brajesh Mehrotra Sir, with a plant, a memento, and a stool. हमारे बीच हमारे मुख्य सचिव बिहार श्री ब्रजेश मेहरोत्रा सर का आगमन आज हुआ है, तो उनका अभिनंदन किया जा रहा है और अभिनंदन कर रहे हैं गृह विभाग के सचिव श्री प्रणव कुमार सर। पौधा, स्टोल और खूबसूरत सा स्मृति चिन्ह देकर। एंड नाउ आप सभी तैयार हैं फॉर द ओपन हाउस सेशन। आपके सामने माइक्स हैं। आपके मन में जो भी प्रश्न है इस 2 दिन का जो हमारा वर्कशॉप रहा उससे रिलेटेड एनी क्वेश्चन अगर आपके पास है, हमारे ऑनरेबल डिग्निटरीज आपके बीच हैं जिन्होंने अपने अपने स्पीच के जरिए इस टॉपिक पर अपने व्यूज को रखा, इंफॉर्मेशन दिया, तो उससे रिलेटेड आप क्वेश्चंस पूछिए, एनी क्वेरीज। वी विल स्टार्ट अ ओपन हाउस सेशन। एनीबडी फ्रॉम राइट साइड, लेफ्ट साइड, बैक? Sir, okay, sir, start. Okay, sir.
Is it working? Yes. I did not really bargain for this because a question answer session, the judges, it's difficult for us to sit through. As the Supreme Court said, we judges have only our judgment and we are not good at answering questions. We are better at raising questions. Sitting on the dais, I don't want to do that, and nor would my brother want to do that. I was, in fact, planning to go out when the question answer session occurred. You have others with you. You have the panelists who will answer your questions. We'll be here for 10 minutes, but permit us to leave after about 10 minutes. Please.
Thank you, sir. Sir, please start.
With the permission of the chair, I would like to first take up the issue with the learned Advocate General flag.
माइक्रोफोन दे दे, आवाज क्लियर नहीं आ रही है। कॉर्डलेस।
With the permission of the chair, in order to initiate the dialogue, I would first like to flag the issue which the learned Advocate General had flagged yesterday. That is with regard to the signing of the electronic information by the informant within 3 days. The issue is that how do we interpret this section 173, 175 and 176? Because while 173 says that an electronic communication shall be taken on the record after it's being signed within 3 days by the person giving it. 176 deals with the procedure for investigation. It states that if from information received or otherwise, an officer in charge of a police station has reason to suspect the commission of an offence, then he will initiate investigation. So, it's a issue which is required to be, at least the learned DGP has also said that there is a SOP and there is some module also developed for purpose of training to the police officers. So how this issue has been taken up and what would be the instruction to the investigating officers, the officer in charge of the police station with regard to these issues?
As I have been able to understand that as in earlier CRPC, no sooner a police officer came to know about commission of a cognizable offence, then it is irrespective of whether information was given to him in writing or not. It was his duty to immediately swing into action and act accordingly. However, in the present BNSS, this is a special provision. Perhaps in days to come it will unfold, but perhaps with a view to entertain an electronic information for registration of first information report and further proceeding in that direction. Therefore, 3 days time has been allowed. However, as I have been able to comprehend, it doesn't mean that if the person doesn't sign it or does not sign it within 3 days or does not sign at all, will render the police to sit idle and not to take any action. That is how I have perceived it. It will depend upon how this section will be interpreted in future by honorable courts. But one thing is very clear, that if a cognizable offence comes to the notice of the police, it is the duty to act immediately. So for this particular provision, maybe the signature, after it is signed, they would be registering a formal first information report. But for that, I don't think that an IO or a police officer need to wait before commencing the investigation. That is how I understand.
That is very correct, sir. That is anybody's take. So does it mean that the information which is received electronically, that is to be essentially entered into the station diary, which I understand. That is required to be entered in the station diary as a sanha, we normally call it sanha. And then on that basis, the police officer will immediately start investigation of the case and will proceed further with that. The DGP has come out with SOP, I think that is taken care of.
May I just take, sir, I'm not a very law expert, sir, but suppose there is a 112 dial, there is a provision of 112 dial wala karne ka, sir. So if somebody dials 112 and says that some offence has taken place somewhere, so the person who is in the vehicle, the officer in the vehicle goes to that place and finds that some cognizable offence has taken place, I think that is where the investigation starts. As a common man, sir, I'm talking about as a common man, not in the parlance of the law or the criminal code or whatever it is, sir.
So I can try and respond, sir, to what you have said. First, the principle is what the learned Advocate General said. I think the principle of law doesn't change. A police officer is duty bound to act if a cognizable offence comes to his knowledge.
Right.
The second part is that our SOP deals with identification, collection and seizure of electronic evidence. it does not talk about what to probably do in such a circumstance. We are following the principles as they were followed earlier. That's it.
Fine. Thank you.
I, District Prosecution Officer Ara, it is true that community service has been introduced for the first time as a penal section in the BNS 2023. Regarding the same, I would like to ask what factors should be considered by the judge before determining the nature and duration of community service.
Yeah, so I'm not able to locate you, but I'll try to answer, which may benefit everyone. So community service, when it was thought of to be added in the Bharatiya Nyaya Sanhita as one of the reformative punishment, it was always in the mind while deliberating on this issue, should we provide a detailed procedure with respect to community service as far as the duration is concerned, the nature of it is concerned, and also the supervision of it is concerned. But ultimately, it was left to the best of the minds of the judiciary, the courts, the judges, that let it be decided by the courts about the duration of community service. And if you take a clue, what could be the possible duration, there is also a section in Bharatiya Nyaya Sanhita, earlier in Indian Penal Code as well, which talk about what would be the default punishment if a person is not able to pay the fine amount imposed by the court. So on the same lines, the fine and community service are kept together in that section where the default punishment is mentioned with respect to community service and default of payment of fine. So that is the only section where some quantum of punishment can be attached to the community service, but of course in default. As far as duration of community service is concerned, it is not mentioned in the code, in the Sanhita, and it is left to the judges, to the court. Depending on the nature of the offence, the court can decide on the same nature, supervisory officer and everything. And there are Supreme Court and High Court decisions on this, where the courts have already given much of the thought and much of the clue which can be followed by the courts with respect to community service.
Okay. Second question, sir. Does the provision of community service...
Just hold on, sir. Can you identify yourself by raising your hand? Where are you, sir? All right. So, before your second question...
Second question. Does the...
Sir, please wait. Before you shoot your second question, let me tell you. See, as Mr. Tiwari has told you and told the House that it has been left to the judge's discretion. But then that discretion is not unchannelized. It is not wide enough to do anything that you wish to. I can only tell you, because I am sitting in the appellate side, if I were the judge and was giving punishment, community service as one of the substitutes of punishment, I would have looked at the nature of offence, the gravity of the offence, whether it could be expiated, and at the same time it was in some way or the other a retribution of a kind. So it all depends upon the nature of the crime, the perception of the judge through the society, because you see, we had a very bad experience of a judge with us. You know, asking a washerman who was accused of an offence, of course a petty offence, to go and wash the clothes of all the women in the village for about 6 months. Well, this is no community service. This is something which the judge went beyond his mandate. Now, therefore, a judge has to apply his mind that you would have heard about community punishment by some for cleaning of the temples, where they ask for keeping the shoes at proper places. Something of the kind which would make him conform to the societal rules, and it would be a kind of expiation for the sins that he has committed, but definitely for petty offences only. So this depends upon the discretion of the court. Now, please hear the observations of the Chief Justice also, and then you can ask another question.
See, for community service, look around you. Look around your society, you will find enough places where you can ask them to do community service. For example, a person accused of rash driving could be asked to control the traffic in front of a school during the time when the school opens and the school closes. The children are coming out, he could ask them to do that. And if you search the Google, I don't know whether you have seen it. I get it because I verify what's happening in the Kerala High Court also. Recently, the Kerala High Court passed a judgment in which the accused were, advocates were proceeded for contempt. In one of the Mofussil centers, the advocates had, abused a judge, for which contempt was initiated by the High Court. And I read recently that what they said was, the division bench asked the advocates to purge their contempt by doing pro bono work in their courts, and asked the Legal Services Authority to keep a tab on the work they are doing, the free pro bono work. See, that's how you look around, you will find enough areas where you can have community service.
Regarding, sir, community service, second question, last humble question, does the provision of community service apply to all minor offences or only a selected category of offences?
Only 6 offences. Details, Mr. Tiwari will tell you.
Good morning, sir.
So to start with, only 6 offences are given where community service is given as an alternate punishment. One is, of course, yesterday we have discussed section 226, where attempt to commit suicide is used to restrain or compel a public servant to perform duty. Second, where the public officer is engaged in unlawful trade. Third, the offence of defamation. Fourth, where the first time offender is involved in petty theft, where the property is less than 5,000 rupees. And 2 more cases are there where community service is given as a specific punishment. Beyond this, the district judiciary cannot pass community service as a sentence, which is of course a prerogative of High Court and Supreme Court for sure. But for these 6 offences only, as of now, it has been introduced in the Bharatiya Nyaya Samhita.
Thanks.
गुड मॉर्निंग सर, मैं धर्मेश कुमार, असिस्टेंट डायरेक्टर प्रोसिक्यूशन। सर, मेरा क्वेश्चन 258 बीएनएसएस और 271 से है रिलेटेड। सर, 258 में सर के पास लिस्ट होगा, कल देखे हुए सर कि लगभग 16,80,000 केसेस में 11 लाख सर मैजिस्ट्रियल ट्रायल का केस है, और जो 258 में सर जजमेंट का टाइमलाइन फिक्स है उसमें कि 30 डेज या 15 डेज एक्सटेंड कर सकते हैं। लेकिन सर वारंट ट्रायल के केसेस जो मैक्सिमम पेंडिंग है स्टेट में या ऑल ओवर इंडिया में सर, उसमें वो टाइमलाइन 271 में फिक्स नहीं किया गया है सर, स्पेसिफिक उसमें लिखा है। और दूसरा, चार्ज में भी सेम चीज है सर, चार्ज के लिए उसमें ऑडियो वीडियो से चार्ज फ्रेम करने का प्रोविजन दिया हुआ है सर 251 में सेशंस ट्रायल के लिए, और वारंट ट्रायल के लिए जो चार्ज फ्रेमिंग का जो दिया हुआ है 263 सर, उसमें चार्ज फ्रेमिंग के लिए ऑडियो वीडियो का मेंशन नहीं किया है, क्योंकि 251 में स्पेसिफिक मेंशन है सब क्लॉज 2 में सर। तो सर ये
तो जहां तक बात है टाइमलाइन की जजमेंट प्रोनाउंस करने के लिए, तो अगर आप 392 पढ़ें सेक्शन, तो उसमें 45 दिन की समय सीमा है जो सब पे एप्लीकेबल है, चाहे वो वारंट ट्रायल हो चाहे सेशंस ट्रायल हो। तो वो समय सीमा 45 दिन की एप्लीकेबल है। अगर किसी और सेक्शन में मेंशन नहीं की है टाइमलाइन, तो 392 जो जजमेंट के चैप्टर में है उसी में 45 दिन की समय सीमा दी हुई है जजमेंट प्रोनाउंस करने के लिए, और साथ ही साथ 7 दिन की समय सीमा है जिसमें कि जजमेंट प्रोनाउंस करने के बाद जजमेंट हैज टू बी अपलोडेड ऑन ई पोर्टल, उसकी बात करते हैं उसमें। तो ये तो हो गया उत्तर आपके पहले प्रश्न का। तो मेरे ख्याल से यही है प्रश्न। दूसरा प्रश्न था,
दूसरा था चार्ज फ्रेमिंग के लिए सर, उसमें ऑडियो वीडियो मीन्स का दिया हुआ है, जैसे विटनेस का एग्जामिन होगा उसमें भी दिया है वारंट ट्रायल का, सेंटर से हो या डिस्ट्रिक्ट से जहां भी हो ऑडियो वीडियो से। लेकिन चार्ज फ्रेमिंग के लिए स्पेसिफिक जो प्रोविजन सब क्लॉज 2 में दिया हुआ है सर, वो चीज वारंट ट्रायल वाले में नहीं है।
जी, वो केवल सेशंस ट्रायल में रखा गया है जो सीरियस ऑफेंसेस हैं। उसी में इसकी सुविधा दी गई है, वारंट ट्रायल में नहीं दी गई है।
सर दूसरा था क्या बेल के लिए जैसे 15 डेज में टाइमलाइन जो है सर 60 डेज और 90 डेज का, कि आप 40 डेज या 60 डेज उसको रिमांड कर सकते हैं। 15 डेज में बाय द वे अगर एक्यूज को बेल हो जाता है और इन्वेस्टिगेटिंग ऑफिसर को लगता है कि नहीं हमको इसको रिमांड करना है, देन तो फिर बेल कैंसिल करने के लिए ही प्रेयर करना होगा सर। ये सारा प्रोसिक्यूटर पर पड़ेगा, दूसरा अल्टरनेट तो है नहीं, क्योंकि जब तक वो कस्टडी नहीं रहेगा हम रिमांड पर ले नहीं सकते हैं, पुलिस रिमांड पर। ये चीज इसमें क्लियर कट नहीं है।
हाँ, क्लियर कट नहीं है, लेकिन दो चीज समझें कि जो 15 दिन की जो पुलिस कस्टडी की समय सीमा है, दैट इज 15 days ओनली। व्हाट हैज बीन इंक्रीज टिल व्हाट टाइम पुलिस कस्टडी में बी सॉट। तो जहां 60 दिन की समय सीमा थी, अब उसमें 40 दिन, और जहां 90 दिन की समय सीमा है जिन अपराधों में जहां पनिशमेंट 10 साल या उससे अधिक है, वहां पे 60वें दिन तक पुलिस कस्टडी मांगी जा सकती है। देना न देना अभी भी विद इन द डिस्क्रिप्शन ऑफ द मैजिस्ट्रेट पहले की तरह ही है। पहले जो शब्द थे जो बहुत ही महत्वपूर्ण है, जो कि अनुपम जे कुलकर्णी सीबीआई वर्सेस अनुपम जे कुलकर्णी का जो केस है 1992 सुप्रीम कोर्ट का, उसमें जिसको इंटरप्रेट भी किया गया है, फ्रॉम time to time and in such custody they have been retained in 187 BNSS, earlier it was in 167, meaning thereby police custody remand PCR is not the norm but only the exception. The very subsection providing for stating the reasons for giving police custody remand is also retained. That means only in exceptional cases should be given first. Now question comes with respect to what if a person is released on bail and then the police officer, the IO request for custody, because now the custody can be sought till 40th or 60th day. For sure, no executive order can take over the judicial order. So once a judicial order has already been passed in the nature of bail, it has to be cancelled first. Then only it can be taken, or the person can be taken in police custody.
प्रोसिक्यूशन पर ही लोड पड़ेगा।
हाँ सर, एक क्वेश्चन सर, मैं कटिहार डिस्ट्रिक्ट प्रोसिक्यूशन अफसर हूँ। एक क्वेश्चन से रिलेटेड है इन्वेस्टिगेशन और रिमांड से सर। एक्चुअली ये प्रैक्टिकली देखा जाता है कि आईओ जब रिमांड के लिए आते हैं कोर्ट में, तो मेमो ऑफ एविडेंस या अन्य चीज़ आता है तो कोर्ट के द्वारा क्वेश्चन पुट किया जाता है कि आपने क्या मेमो ऑफ एविडेंस लाया है, मैं इसके क्यों रिमांड करूँ। तो ऐसी स्थिति में न्यायालय के द्वारा कभी कभी पब्लिक प्रोसिक्यूटर को कहा जाता है कि आप बोलें कि क्या इसमें मेरा लोकस स्टैंडर्ड बनता है कि नहीं बनता है, बोलना। फर्स्ट का सोमोटोरियट जो सुप्रीम कोर्ट का है उसमें स्पष्ट कहा गया है कि एट टाइम ऑफ रिमांड पुलिस डिपार्टमेंट को अपना अलग से एक एडवोकेट रखना है, फिर भी हम लोग उसमें हेल्प करते हैं। तो मेरा सर यही सजेशन इसमें है कि दिया जाएगा कि अगर इन्वेस्टिगेशन के दौरान उनको कोई प्रकार का अगर कोई प्रॉब्लम आता है लीगल एडवाइस को, तो वो एडवाइस ले सकते हैं। और आफ्टर सबमिशन ऑफ चार्जशीट उसमें तो हम कुछ कर नहीं सकते हैं। तो देखा जाता है कि आफ्टर सबमिशन ऑफ चार्जशीट तो हम लोग के पास आता है ओनली फॉर फॉरवर्ड, तो फॉरवर्ड करके हम लोग उसको देखते हैं, कुछ उसमें लिखना पाते हैं तो कहते हैं इसको सुधार। तो वहाँ से जवाब आता है आईओ का कि अब तो फाइनल इसमें मेमो कर चुका है, इसमें कुछ नहीं कर सकते हैं। तो उसको हम लोग कोर्ट के पास देते हैं। एट ए टाइम ऑफ कॉग्निजेंस जो है लर्नेड कोर्ट उसको देखते हैं कि सेक्शन में लेना है अथवा नहीं लेना है, अकॉर्डिंगली वो संज्ञान देते हैं। तो इस स्थिति में हम लोग का क्या रोल है, लोकस स्टैंडर्ड बनता है या नहीं बनता है?
तो जो प्रोसिक्यूशन से जुड़ा जो बदलाव है सेक्शन 20 में भारतीय नागरिक सुरक्षा संहिता में, वो एक ऐसा बदलाव है जिसमें कि अब डिस्ट्रिक्ट जो डायरेक्टरेट ऑफ प्रोसिक्यूशन है उसकी स्थापना करने का प्रावधान किया गया है। उसके माध्यम से ये प्रयास है कि चूंकि डायरेक्टर, डिप्टी डायरेक्टर और असिस्टेंट डायरेक्टर, ये तीन जो उसमें अथॉरिटीज होंगी, उसमें अगर आप डिप्टी डायरेक्टर की अथॉरिटी को अगर पढ़ें, वो सब सेक्शन पढ़ें, तो उसमें दिया गया है कि डिप्टी डायरेक्टर, हालांकि तीनों अथॉरिटीज जो हैं वो केस के प्रोग्रेशन को मॉनिटर करेंगे कि कहीं अगर कोई दिक्कत है तो उसको खत्म किया जाए, दूर किया जाए, ताकि केस इजिली आगे बढ़े। दूसरा जो डिप्टी डायरेक्टर का प्रोविजन है, उसमें डिप्टी डायरेक्टर के लिए जो कि 7 से 10 साल के तक के जो अपराध हैं उसमें जिसमें कि मॉनिटरिंग दी गई है, उसमें यह भी प्रोवाइड किया गया है कि पुलिस रिपोर्ट को स्क्रूटनी करने का पावर भी डिप्टी डायरेक्टर को दिया गया है। तो एक क्वेरी जो इस कानून के आने के बाद आई थी मंत्रालय में, गृह मंत्रालय में, जो कि जम्मू एंड कश्मीर से आई थी, वहां पे भी यही प्रश्न आया था कि मतलब क्या जो किशन भाई का केस है 2014 का सुप्रीम कोर्ट का, जिसके बाद किशन भाई के केस में सुप्रीम कोर्ट ने कहा भी था स्टेट ऑफ गुजरात वर्सेस किशन भाई में कि अब ये दायित्व होगा पब्लिक प्रोसिक्यूटर का कि कोई भी ऐसी चार्जशीट बिना वेट किए ना जाए, और जो भी कुछ फ्लॉज हैं, डिफेक्ट्स हैं, उनको पहले ही क्योर किया जाए चार्जशीट में को कोर्ट के समक्ष प्रस्तुत करने के पहले। तो लगभग उसी दिशा में ये एक डिप्टी डायरेक्टर का जो एक पावर है उसको रखा गया है। बियॉन्ड दैट और कोई बदलाव प्रोसिक्यूशन से जुड़ा हुआ नहीं है। न तो प्रोसिक्यूशन को इन्वेस्टिगेशन में इंटरफेयर करने का पावर दिया गया है, क्योंकि वहां सेपरेशन ऑफ पावर को मेंटेन किया है नए कानून में, और सुप्रीम कोर्ट की मंशा भी किशन भाई में यही थी कि एक बार इन्वेस्टिगेशन खत्म हो जाए उसके बाद ही प्रोसिक्यूशन उसमें अपना माइंड अप्लाई करे। तो उसी दिशा में नया कानून भी प्रयास करता है कि डिप्टी डायरेक्टर जो उसको 7 से 10 साल वाले केसेस में पावर है वो उसमें स्क्रूटनी कर सकता है, बियॉन्ड दैट नहीं।
हम तो चाहेंगे सर कि डिस्ट्रिक्ट लेवल पर जो प्रोविजन आया है डिप्टी डायरेक्टर, असिस्टेंट डायरेक्टर का अगर प्रोविजन है तो जल्द से जल्द करवा दिया जाए। सारे लोग सर हैं, ऑनरेबल कोर्ट हैं, जजेस हैं, अगर हो जाए तो बहुत अच्छा रहेगा सर काम करना।
डायरेक्टर प्रोसिक्यूशन के एस्टेब्लिशमेंट को एस्टेब्लिश करने के लिए सरकार के स्तर पर कार्रवाई प्रारंभ की गई है
सर।
उसमें बीएनएसएस में समय सीमा भी निर्धारित है सर। ये पूरा इंफ्रास्ट्रक्चर तैयार करने में समय लगने की संभावना है
सर।
बीएनएसएस में जो भी जिम्मेवारी दी गई है
सर
सरकार के लेवल पर या पुलिस के लेवल पर, उन सब को पूरा किए जाने की दिशा में कार्रवाई की जा रही है
सर।
डीजीपी साहब ने आपको थोड़ा विस्तार में बताया
सर।
और जैसे इंफ्रास्ट्रक्चर स्ट्रेंथन करना उसी का पार्ट है प्रोसिक्यूशन, डिस्ट्रिक्ट प्रोसिक्यूशन इंफ्रास्ट्रक्चर को इस्टेब्लिश करना। मुझे उम्मीद है कि इस दिशा में सकारात्मक कार्रवाई के परिणाम जल्द दिखेंगे।
धन्यवाद सर।
Good afternoon. I am from Sitamarhi. Legislature in its wisdom has departed from section 156(3) CRPC to 175(3) BNSS, and it went on to say that while passing order for registration of FIR by court, the submission of police officers has also to be taken care of. If I would be permitted to read the provisions of law existing as on date, any magistrate, I am reading out section 175 subsection 3 BNSS. Any magistrate empowered under section 210 may, after considering the application supported by an affidavit made under section 173(4), and after making such inquiry as he thinks necessary, and submissions made in this regard by the police officers, order such an investigation as above mentioned. So it appears that there is a clear departure from previous 156(3) CRPC to 175(3) BNSS. So my question is how that has to be applied, from which the submission of which police officer has to be taken care of while passing order under section 175(3) BNSS.
So the idea was,
see, so far as taking cognizance is concerned, there is the R.R. Chari's case, which is a 3-judge bench decision on private complaints, where it was stated that cognizance in private complaint is taken when the magistrate applies his cognitive faculties, that is his mind, and then decides to proceed under chapter 15 of the old code. That is so far as old code is concerned. So R.R. Chari's case, going by R.R. Chari's case, even the sworn statement, if you decide to take sworn statement the next day, you take cognizance of the offence. The taking sworn statement of the complainant is a post-cognizance stage, as contemplated, as enunciated in R.R. Chari's case. Now, as you said, there is a clear departure, because now you have to give notice to the accused, and after he comes, and after he comes, then alone you can take cognizance of the offence. Even taking a sworn statement, reading the RR Chari's case with the new code, after the accused come, only then you will be permitted to take cognizance under the new code. That is the distinction which I have found in this.
My learned friend has answered another question which would have been in everyone's mind about 223. Now coming to the specific question of 175.3, the idea was to introduce what has already been introduced in Priyanka Srivastava case 2014 Supreme Court by the Honorable Supreme Court, that no person should take the recourse of magistrate to get a direction for registration of FIR unless the already established procedure of 154.1 and 154.3 have been exhausted. Now that has been introduced in the law in 175.3. Now second change which has been introduced and already in practice in Delhi at least, where whenever a 156.3 application is received by the magistrate asks for action taken report ATR by the police officer concerned of the Thana police station, and after that only the magistrate decides whether to refer the application so filed for the purpose of registration of FIR or not. So these two changes are introduced now in the law, one which is directly related to the Supreme Court's decision in Priyanka Srivastava, and other which relates to the practice in different parts of the country, which has now been made part of the new law in 175.3.
District Police Prosecutor Saharsa, in new CRPC, the post of assistant judge has been abolished. Now the question arises, who will conduct the case? The CJM notification was issued. The CJM as assistant judge, he was conducting the trial. Now the post has been abolished. Question arises now, who will conduct the case, whether additional session judge or assistant judge?
Hello, yeah. So I think your question is on abolition of a couple of courts and designation like metropolitan area, because that resulted in deletion of metropolitan magistrate and the cadre of assistant session judge, isn't it? Can I get a confirmation from you?
Assistant session judge.
Yes.
I'm
coming to that. Yes.
Judge.
So now what is?
Who was conducting the case in which they were imprisonment of 10 years. The case was being conducted by the assistant session in new CRPC. That post has been abolished. Who will conduct the case?
Yes. So the idea is now the high courts, the chief justices of different high courts, they are coming with their own notifications. I think Delhi has done it. In case of metropolitan magistrate, they have notified on 1st of July that metropolitan magistrates will be now designated or re-designated as judicial magistrate first class, and they have listed and given the numbering also. So I believe it has to come from the Honorable High Courts that these cases which were earlier assigned to assistant session judge, now because that position has been deleted in the new Sanhita, which authority will be invested with that? I think the honorable judges may be in a position to answer it better than me. Thank you.
If you look to the schedule to BNSS at the end of it, you'll find the jurisdictional court according to prescribed punishment for the offence has already been defined. Which class of cases will be tried by magistrate and which class of cases would be tried by sessions court, that has been given in the schedule to BNSS. So wherever the cases were pending will have to be reassigned in accordance with the schedule to BNSS. That is how I understand it. Now there is no concept of magistrate second class, magistrate third class and assistant session judge. In Bihar as such, there has been no second class and third class judicial magistrates. Assistant session judge are also not in existence. that is what I answered. That will have to be reassigned according to the schedule given at the end of BNSS, which defines which class of cases will be before which is.
I don't think we'll have to look at it because assistant sessions judges as of now, if their jurisdiction is taken away, there is no question of any further notification. But then we'll have to examine it further because in Bihar especially, if the senior division is confined to the civil work, we may have problems, but then we'll see what happens in the course of time. And as it is, the district judges and additional district judges are burdened with work.
Sir, so schedule Bharatiya Nagari Suraksha Sanhita continues with the same schedule where the sessions court is mentioned, not this. So in case of magistrate, it is in two ways: any magistrate and magistrate of first class. For sessions court, it is mentioned only sessions court, not divided into assistant, additional or sessions court. But the power comes from one of the sections earlier in CRPC which got deleted, where under the assistant session judge was given power or was empowered to try the cases where the punishment is up to 10 years. So now that gets deleted. But the schedule allows the sessions court to still try the cases, but yes, pending cases are to be tried by the same court as long as the case is pending before the assistant session judge.
So in future it cannot be. You have repercussions. In between, I just pass on one information which is relevant for everyone and mostly for the police officers. Very recently, the Home Ministry, the Union Home Secretary has, I think, sent a letter due to all the Chief Secretaries of states, where under the designated place from where the witnesses can record their statement or give their testimony for court proceeding should not be any place under the control of police department. So that means the police stations and any premise under the control of police department cannot be the place for the purpose of recording a statement of a witness within the meaning of designated place under section 265 and 266 and for the accused 308 in Bharatiya Nagari Suraksha Sanhita. So kindly take note of that. Thank you.
I have one small more queries. Unlike section 190 CRPC, section 233 BNSS again incorporates the principle of RD alteram partem. It says the first proviso to section 223 BNSS, if I would be permitted to read out, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. If this is read along with the earlier provision 192 CRPC, where the CJM at the time of admission of the complaint was empowered to make over the cases for inquiry and other proceedings upon the complaint to the magistrate subordinate or equivalent to the court of CJM. Now the question is, section 192 earlier, which it was saying that magistrate, this court of CJM or the magistrate, after taking cognizance, he makes over the case. So the question is, at what point of time, suppose the complaint petition is filed in the court of CJM, the complaint is admitted, and now the court of CJM is willing to make over it to the court subordinate to it. At what point of time, my question is, at what point of time the hearing to the accused be given? Please enlighten us.
There are two situations. One is a sessions case. Insofar as the sessions case is concerned, you give notice to the accused before taking cognizance, and then there is no question of any other proceeding even under the new BNSS. You commit the case once the accused is before you, see whether the final report's copy is given, whether all documents are there, and then it is sent to the sessions court for, and at that point of time, sessions court, after receiving the file, will frame charges under the new provision, going through the police report after hearing the counsel for the accused. Even under the new code, Sessions Court does not look into any of the documents produced by the accused at that point of time. So far as the magistrate taking cognizance of a Sessions case is concerned, he has also no role. He cannot add any accused under 319. Now, so far as a complaint case is concerned, obviously after issuing notice to the accused, you have to conduct an inquiry. And after conducting the inquiry, alone then the committal comes. So this is the distinction. That the same thing is there in the CRPC, I mean the new BNSS and the CRPC. Only thing is, before all this taking cognizance, there is a point the accused comes to know matter is pending before him. Now, yesterday I was listening to the DG, police, I think ADGP or somebody, he was saying, after he leaves the station, after 3 or 4 years, somebody files an application under 156(3) and the case is registered against him. So it looks very awkward, maybe a frivolous case. So at the time when the complaint under section 200 is filed, before taking cognizance, he comes to know. Not that he can do anything about it, but he comes to know. At least he has noticed. So I don't think there is anything wrong in that provision. But so far as courts are concerned, there is an additional impediment. Before taking cognizance, you will have to issue notice to the accused.
Sir, one query I have. Sir, if the notice to the accused is as per BNS, then how a notice or a process can be issued by the court for hearing the accused during the cognizance?
Once the accused is before you, there is no question of again issuing process, because he is already there, he knows about the proceeding.
Sir, before taking cognizance, we are required to hear the accused. Then how we will ensure the presence of the accused?
It does not say that you have to hear the accused. It only says,
in the complaint cases, the accused is out of the scene, and how we will secure the attendance of the accused?
that is under the old CRPC. Now there is a change in the new CRPC. It says, provided that no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. So
Yes,
he
yes.
actually will be before you.
The summon, warrant and NBW, what should be the process limited?
Earlier, after cognizance, you issue a summons.
No, earlier even the sworn statement is after cognizance.
That's true, true. And after that only you issue summons. True. What she asks is, now how do we get the presence of the accused?
Yes.
No.
Notice, issue notice.
No, notice is given before taking cognizance.
Yes, sir.
You are heard.
Yes.
You hear the accused.
No, if on notice the accused doesn't appear, then?
Does not appear, then
Yes.
you will have...
Then we will proceed with the cognizance and...
Naturally, what is the
That is deemed to be. Suppose he refuses cognizance, notice. He is deemed to have notice. Yes.
Okay.
See, when any provision says that,
Yes.
hear the person who is prejudiced, it only means that give him an opportunity of hearing.
Okay.
If he doesn't turn up, well, that is his default.
Okay. Thank you.
There is slight gray area in this. If
Sir.
the accused has to be heard before process is decided to be issued, the next question is, to what extent the
Yes,
accused has to
yes,
be heard?
exactly. Whether we can summon, we can issue warrant or only notice.
In the garb of hearing an accused, the trial court is not expected to conduct a full dress.
And there cannot be any warrant issue, definitely.
Okay.
Because it is not for you to have the presence of the accused mandatory.
Okay.
See, that is an opportunity given to the accused, for which you cannot issue.
And it's more like a right which has been conferred on the accused, sir. Not a coercive action to be taken to mandatorily have his presence. You issue notice. If he is willing to make himself appear before the court, well and good. Otherwise, you proceed to take cognizance because you have done your part of the job as a judicial officer.
But there is another risk that the complainant, cunning and clever complainant may manage
File
to-
the wrong address of the accused.
Yes, something
And
like
in that case,
So court has to be cautious that notice is at least served to the proposed accused. e-notice. Now there are electronic notices recognized mode of service. So that is one responsibility cast on the court, that notice is at least served to the accused.
After the service, we will proceed with the cognizance and others. Okay, sir. Thank you.
So good afternoon, sir. I am Assistant Director in Forensic Science Laboratory, Patna. My question regarding the 65B, because I have got a request from a prosecution officer. He kindly give the certificate, 65B certificate regarding the cyber crime report. So, so I asked about, I want to say that he, in case of State of Karnataka versus T. Nasir and others, on dated of 6 November 2023, Honorable Apex Court have given the order that, so in my view, that is no need of the certificate giving under the 65 and in 65B. But they asking what I will do then. So I can give some suggestion or instruction about this in light of that judgment.
Your question, because 65B certificate I got that much, but what is the context of 65B in your question?
Sir, FSL produced the report, what he gets the digital devices submitted to the FSL. After the giving the report, they returned the digital device to the court, and many prosecution officers are asking that they also produce 65B certificate. So, can I, when I read the Apex Court order, State of Karnataka versus T. Nasir, I read that para 14, in which that Apex Court say that there was production, there was no need to produce the certificate under section 65B of the Act. So, what I will be thinking, that was produced 65B certificate or not?
In fact, the other mode, that is overruled, specifically in Arjun Pandit's case. Now, secondary evidence, adducing of secondary evidence, Arjun Pandit, they have specifically said that this certification is a must. So, Lord Goddard's view, which was there in England, and that was followed in Navjot Singh Sidhu's case, Parliament attack case, that is specifically overruled. Now, your new evidence act contains a form also of certification, because to make things
Sir, but my question is, I am primary evidence submitted to the court after the examination. So then, with the special report, they were submitted, can submit, asked about the 65B certificate, because primary evidence already submitted to the court.
So the certificate is to be issued in two forms. One is Part A and Part B. Part A is to be signed by the person in whose possession the electronic device had been, whether it's a computer or something else. And Part B is to be certified by an expert, meaning that the contents of the certificate, priorly given by the custodian of the device with regard to the contents, are true. I mean, the hash value, the other informations that are given there, it's true. So it is twofold.
Easier question that once in the trial court that certificate is not produced, there is no way of producing it. Is that your question?
So sir, with the permission of the chief, may I reply to this question?
Yes.
So I got your question about the primary evidence actually. So the law has made it very clear. If you are submitting any electronic evidence as a primary evidence, then the certificate is not required. Only when the electronic evidence falls in the domain of secondary evidence, you require to produce certificate. Now the certificate is made part of the Bharati Sakshya Adhiniyam in Schedule 1, and it has to be generated at every stage. In every hand, the electronic evidence goes through. That is one. Secondly, if you see, there is also in charge sheet 193 now, there is a provision subsection added for the police officers. The sequence of custody of electronic device has to be mandatorily mentioned with the charge sheet to the court. So where it is of primary evidence in that nature, then certificate is not required. But of course, otherwise it has to be.
So far as the certificate, the form, I just read out the form. You have to mention the name, and then he should state that I do hereby solemnly affirm and sincerely state. So, the produced electronic record output of the digital record contained in the following device record source and the DVD number, IMEI number, then cloud from where you have got, suppose it is iCloud or if it is OneDrive, you have to say that. And then I state the hash value of the electronic record is dash obtained through various methods are there. SHI method, SHA2 method, MD5 method. Which method you have obtained the hash value, that also has to be mentioned in the certificate, so far as the expert certificate is concerned. The other certificate under Part A, again, is in the form of an affidavit. And he should say that from where he has got the DVD, that he was in the control of the DVD, or he is the person who has got the recording sent through him. So these aspects are there. So it is, in a way, it is very, I mean, with the certificate, when the secondary evidence comes before you, it will be very authentic. Now, so far as the first part is concerned, the digital record, if it is produced in your mobile phone, you have recorded, you are producing it in court, and your mobile phone is produced, then that is a primary evidence. It is not a secondary evidence. There is no question of certification, because the definition of primary evidence contains these kind of electronic evidences also. Now, one area where this has gone well with the new BSA is the provision relating to electronic evidence. Thank you.
Jain sir. Sir, I'm Lalit Sharma, SP Camur sir. So my question is related to BNS section 111. As the land dispute, so the offence of land grabbing is mentioned in section 111 for BNS, but the ingredients of land grabbing has not been defined. Number one. Second question is section 111 is related to the repeat offenders. So where will we register the offence of land grabbing for the first time? Many people are coming in the PS to get this FI registered under land grabbing, but we don't have any sections for land grabbing for the first offenders. And when we do not register case under land grabbing for the first offenders, then how will we register, who will be a repeat offender? This is the problem, sir. Thank you, sir.
So, the organized crime section 111 of Bharatiya Nyaya Sanhita, I think that is the section you are referring, where land grabbing is used as one of the instances of to be considered as organized criminal activity within the meaning of 111, which has not been defined anywhere in Bharatiya Nyaya Sanhita for sure, and even the explanations do not provide any help in ascertaining what amounts land grabbing. So I think your question is a very genuine question, because if it is not defined and there is no section which already covers this act of land grabbing in the Bharatiya Nyaya Sanhita, so how to ascertain the earlier charge sheet and the fresh charge sheet to be filed for invoking 111 in such cases? So I believe yeah, but land grabbing which has been mentioned in that section is the 111.
No evidence. There is no proof of the fact, there is no charge of the fact that it is by virtue of some organized crime that land is being grabbed. See, land grabbing was not an offense in the earlier court law. The other sections, I mean, it fell in some of the other. Likewise here, if land grabbing by what? Suppose there is a bona fide land dispute, and one person thinks that the other person has encroached upon his land, then that is trespass, encroachment, whatever. If it is public land, then perhaps anti-encroachment, but merely land grabbing, that is not one of the offences described, as snatching has been added. So this has to be seen in the context, and the police officers shall find out whether this is an offence, because any other offence, whether it touches any other offence. Otherwise, land grabbing as such is not an offence which has been identified and listed in the schedule.
So to provide you some help with the very explanation which defines continuing unlawful activity, so any activity where the punishment is 3 years or more is designated as or defined as continuing unlawful activity in 111. So I think the clue can be taken from that, which all sections can be invoked for covering the land grabbing activities within the meaning of 111 under the continuing unlawful activity.
Right, sir, but sir, there is a very thin line difference between land dispute and land grabbing. And land dispute is the tool that land grabbers use to grab a land. So for a police officer, it's very difficult to decide from where to draw the line between land dispute and land grabbing, sir. So we are facing difficulty when a people comes to register an FIR for land grabbing. We really find it very difficult to find the right section to register an FIR on the land grabbing, sir. That is the problem we are facing at the police
Now,
station
the problem,
level.
I
Thank you,
just
sir.
wanted to ask another thing. Is there any land grabbing act in Bihar against land grabbing which defines the land grabbing offense? Because in Andhra Pradesh, there is an enactment for land grabbing and they have made it an offense punishable under that act. Okay. But I just want to know whether there is something...
No, sir, no, sir. Land grabbing for the first time has been used as a crime, sir, in Bihar, sir.
That's right. So broadly, if a new offense that is defined in 111, that is organized crime syndicate and other things, such things are there. It will only apply after if it is committed after 1st July. Before 1st July, it is the old IPC that will apply. You have to just look into the old IPC. The new BNS, Nyaya Samhita, will only apply after the 1st July. That is by virtue of Article 20 of the Constitution also, right, with the repeal and savings provision you find in the BNS.
Sir, one question from my side, sir. Hello? Am I audible, sir? Sir, I am a law officer in the Home Department. My question relates to Section 69 of Indian Bharatiya Nyaya Samhita, sir. So far I can comprehend, the essence of this section lies in allurement for sexual intercourse by employing deceitful means. My question is whether within the purview you employing, whether concealment of religion or caste comes within the purview of employing deceitful means. Second question is, if the promise was, how to differentiate? If the promise, the person making the promise made a bona fide promise at a time it was made, but subsequently due to reasons or acts or omissions not attributable to any willful conduct on his part, he subsequently couldn't fulfill his promise. So how the honorable courts are going to differentiate between the promise which was made bona fide but couldn't be fulfilled and promise which was made false at the time it was made?
There is a problem in Section 69 which everybody has to look at. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her. So the question arises as if he fulfills it, will it not amount to an offense? That's a very tricky question.
No, sir. The question is, though it can be one aspect of the question, the essence of my question is, if the person who made the promise made bona fide promise at the time it was made.
Sir, can a woman be? That's a question. Everybody will have to be think about. Can a woman be asked to have sexual intercourse and on some promise, and if that promise is fulfilled, will it go out of the offense? I would say it will not.
Now,
that is again consent obtained by promise.
see, the background in which this offense was added or explained was the rampant, complaints about sexual, sexual advancement and sexual act on the promise of marriage, or perhaps promise of giving promotions, promise of employment. Now, the regular defense of the accused in such cases was that this is consensual, because the lady had been agreeing to it, had been submitting to such deceitful means for a long time. And more often than not, many a time, seeing that it was spread over a long period of time, the courts also thought that perhaps this is a cooked up charge and the defense was justified. In order to cut down this, Section 69 has been added, where you have instances, many instances of people entering into sexual relationship on the promise of marriage. Mere promise of marriage, which is a civil liability, many of the judgments of the Supreme Court, like Dilip Singh versus so and so, and I would not remember the citation, they say that this is not rape per se. In order to avoid all this confusion, Section 69 has been added. This is a new offense where even if you say, if the intention was to deceit, intention was to defraud the victim, and then taking advantage of her gender and subjecting her to sexual intercourse, that is a specific class of offense. So therefore, this, now, Honorable the Chief Justice says that suppose he fulfills this, he promises to marry, he marries, then perhaps the lady has no other reason to complain. So if he comes out of it, there is no offense. If it doesn't come out of it, it's a separate class of offense against gender for by using deceitful means like promise of marriage or giving promotion or giving some advantage. That's it.
So the question would be, after it comes to court, he agrees to marry.
No, that
will it prove intention at the time?
No, that again is
This is
Sir,
a very difficult
another question arising out of the same section, sir, you lordship.
Situation because
if the woman to whom promise is made, voluntary.
Marriage and promotion. Discipline include inducement of false promise of employment or promotion or marrying by suppressing identity. By suppressing identity.
Sir, another question arising out of the same section, sir. My question is, if the concerned woman voluntarily submits to sexual intercourse, but after the promise is not fulfilled, she lodges a complaint under the same section.
Sir,
how?
This is really a factual situation. Now, so far as this offence is concerned, when does the offence occur? Is it at the time when the promise is made, or is it at the time when the offence, that act is committed, or is it at the time when he backs out of the promise? So this is a particular tricky situation, and these things can only, this is a fact situation. This can only be answered in a case which comes before the court and at the trial, and as Madam has pointed out, when the facts are analyzed, because Section 69 also is prospective in application. It will only apply after the July 1st. No, that is why I asked, where is this, when is this offence committed? So this has to be answered in a proper judicial decision. So we cannot hypothetically at this point of time describe subtle nuances of this offence and then answer all the questions. Thank you.
हेलो सर, मैं डिस्ट्रिक्ट प्रोसिक्यूशन अफसर बेगूसराय राधेश्याम प्रसाद बोल रहा हूँ। यहाँ सर नए भारतीय साक्ष्य अधिनियम में जो तब्दीलियाँ आई है, फोरेंसिक इन्वेस्टिगेशन, ओरल ऑडियो रिकॉर्डिंग, वीडियो रिकॉर्डिंग, उसमें सर देखा जाता है विशेषकर रेप के केस में 376, अब जो 64, 65, 67 वगैरह हो गया है, एफआईआर डिले होता है जब, और फोरेंसिक एविडेंस के बहुत सारे जो अपॉर्चुनिटी होते हैं, जो एविडेंस होते हैं, वो नष्ट हो जाते हैं, और जो विक्टिम होती है उसके पास ले देकर ओरल एविडेंस ही सर बचता है। तो क्या ओरल एविडेंस कन्विक्शन के लिए सफिशिएंट है सर? फोरेंसिक इन्वेस्टिगेशन से कोई नीडफुल रिजल्ट आने की पॉसिबिलिटी नहीं रहती है।
It will depend upon circumstances. Solitary evidence of prosecutrix would suffice to justify conviction. There is no necessity. That's right. So it has to be contextual and not necessarily that the evidence of prosecutrix need to be supported with the aid of number of other evidence. And I'm rather surprised, how can electronic evidence be destroyed? Electronic evidence can't be destroyed. It will remain. You refer to destruction of electronic evidence. That is not possible. Once something goes in air, it is not destructible. I think that one has to look at it.
See, the forensics would be on the electronic, it remains on record. The medical report, the fingerprints, the serological examination of blood, then chromatography test, all these would remain on record. How would it be destroyed, number one? And even if it were there on record, if the oral allegation is believable, then it has to be given precedence over all these. Suppose a lady says that I have been gang raped. The evidence is that there was no injury on her private parts, nothing was found, no semen, no blood, no bruises, nothing of that was found, and the age of the girl. See, this is what justicing is, and therefore we did not want to answer questions. These are illustrative cases which come to court for decision making as to under what circumstances can we say that the woman is stating correctly or the accused can be given benefit of doubt. It all depends. But as a thumb rule, it cannot be said that oral evidence needs to be supported by medical evidence. Of course, there is a caveat that oral evidence has to be believable and the witness is a sterling witness. So therefore, these hypotheses, if you put to us, we will not be able to answer you. It all depends upon context and the evidence against the accused.
एक सेकंड क्वेश्चन है सर, बेनिफिट ऑफ डाउट जो है वो प्रोसिक्यूशन के लिए बहुत ही खतरनाक होता है। हम लोगों को केवल इस आधार पर बेहतर कन्विक्शन रेट नहीं दे पाते हैं कि बेनिफिट ऑफ डाउट एक्यूज के फेवर में चला जाता है, और सर और इसमें बचा हुआ है। यहाँ सर ऑनरेबल सुप्रीम कोर्ट के द्वारा जो डिसीजन दिया गया है कि माइनर एविडेंस, माइनर जो सर कंट्राडिक्शन हो रिहाई का आधार नहीं बन सकता है, लेकिन अक्सर देखा जाता है लड़ने कोर्ट के द्वारा इस चीज़ को इग्नोर करके बेनिफिट और डाउट को ज़्यादा इम्पोर्टेंस दिया जाता है। इस वजह से सर प्रोसिक्यूशन अक्सर फेल हो जाता है। तो यहाँ जो नया एक्ट सब आए हैं, क्या प्रोसिक्यूशन के लिए कुछ फेवरेबल है जो बेनिफिट और डाउट पर हावी होकर प्रोसिक्यूशन को बेहतर रिजल्ट दे सके?
मैं आपका क्वेश्चन समझ गया। आई कैन नॉट प्लेस यू, आई कैन नॉट लोकेट यू वेयर एवर यू आर। कैन यू जस्ट रेज योर हैंड?
थैंक यू सर।
हाँ, देखिए साहब, पहले तो यू मस्ट हैव योर बेसिक फैक्ट्स करेक्ट। You are never, judged by the number of convictions that you secure in a case as a prosecutor. That's not the indicator of your being a good prosecutor. So you forget about that. You need to assist the court on the basis of the evidence. You are, to use the old cliche, you are no persecutor. You are only a prosecutor who would assist the court in unraveling the truth. That's one. Therefore, don't be afraid of it. Number two, you see, the law is very well settled with respect to a doubtful evidence. The benefit of doubt. The Privy Council, the judges of England, Indian courts, Supreme Courts and our High Court, other High Courts, they have explained it, what is benefit of doubt. See, nobody expects a judge to be a doubting Thomas. We just can't doubt on improbabilities. Doubtful means if the prosecution is not able to prove its case beyond all reasonable doubts, then perhaps the benefit of doubt has to be given. There cannot be two opinions about it, about the efficacy, about the correctness of this proposition. See, you are convicting somebody of an offense which the court, the prosecutor and the other stakeholders have not seen it happen. So unless it is proved beyond all reasonable doubts, no conviction can be recorded. But there is a caution that every time you don't doubt everything. What is doubtable is doubted. Now that cannot be a ground for you to say that you do not get rated as a good prosecutor. That should not be your objective, and that perhaps would not change the perspective of a judge also.
No, sir, there is a passage. I just want to read out a passage by one of our greatest judges, that is Justice V.R. Krishna Iyer. He says, the excessive solitude reflected in the attitude that 1,000 guilty men may go, but one innocent martyr shall not suffer, is a false dilemma. Only reasonable doubt belongs to the accused. Otherwise, any practical system of justice will break down. and lose credibility with the community. If unmerited acquittals become general, they tend to lead to a cynical disregard of the rule of law, and this in turn leads to a public demand for harsher legal presumptions against indicated persons and severe punishments. So he says that jurisprudential enthusiasm should only be shown for reasonable doubt, not every hunch, hesitancy and which comes to the person's mind. So only reasonable doubt is what is permitted in the golden thread of that rule of law, named as beyond a reasonable doubt. So in Shivaji Rao's Bot-based case, gives a very, in fact it is, there is a he says that harsher presumptions will come. Now because of unmerited acquittals in certain cases, you find POCSO acts, the economic offences, all have reverse burden clauses. So whether this is good or not, it is our own doing because of our excessive devotion to the theory of burden of proof. That is what Krishna says.
Thank you so much, sir. With the permission of Honorable Mr. Justice K. Vinod Chandram, the Chief Justice, Patna High Court, we conclude this open house session. And for the vote of thanks, I would like to request Srimati K. Suhita Anupam Ma'am, Special Secretary, Home Department, Government of Bihar.
Distinguished Chief Guest of this two-day workshop, Honorable Justice, Chief Justice of Patna High Court, Honorable Mr. Justice Krishnan Vinod Chandran, Honorable Mr. Justice Ashutosh Kumar, Honorable Justice Ananya Bandyopadhyaya Ma'am, all Honorable Justices of the Patna High Court present, the learned Advocate General P.K. Shahi Sir, Mr. Sri Harinder Nath, Senior Advocate, Kerala High Court, respected Chief Secretary Bihar, Brajesh Malhotra Sir, DGP Bihar, Bhatti Sir, Principal Secretary Home, Arvind Chaudhary Sir, Director BPA, Brigu Srinivasan Sir, all DG rank officers present, and all officers of judicial administration and also senior SPs, DMs, DIGs, IGs, and all my dear officers present from FSL. A very good afternoon to you all. The time is always right to do what is right. This was said by the American civil rights activist Martin Luther King. So we are all here in this workshop to understand the nuances of the new criminal measure acts. There are deadlines to meet and goals to achieve. So we need to set smarter goals that are specific, measurable, achievable, relevant, and time-bound. We also need to deploy the right strategies to achieve it. FSLs and videography of the crime scene is the new norm. My sincere thanks to the Honorable Chief Justice of Patna High Court. He has been an embodiment of what God's own country, that is Kerala, to whom Sir belongs to, stands for. Simple, empathetic, and a visionary. He has been the guiding light to organize these workshops, to sensitize all of you and create awareness so that you also would carry out the same in the districts. As Rabindranath Tagore said, you cannot cross the sea merely by standing and staring at the water. You are all capable as good DMs, SPs and judicial officers in the district to not only cross the seas but also oceans if we want to do this and achieve it. I also like to thank Honorable Mr. Justice Ashutosh Kumar, who has yesterday given his own address about the nuances of the new acts. My sincere thanks to Honorable Justice Joymala Bagchi, who has eloquently brought about the overview of the new criminal measure acts. The second session by Senior Advocate Sri B.G. Harinder Nath gave us an insight of the use of technology and the uniqueness of hash numbers of the digital documents we need to document now. Thank you so much, sir. The third session of Neeraj Tiwari, who has been part of the amendment or the new acts, he was a person who knows the nitty-gritty and integrity of the new acts. It has been knowledgeable and enriching and also refreshing to have you again here and to listen from you about the new acts. Thank you so much. It is the request of most of the DG rank officers to share your presentation if it is possible. The fourth session by Brigu sir, the director, Bihar Police Academy, has been briefed about the investigation challenges to train the police personnel and to be aware of the new acts. Here, I would also like to mention that the Bihar Police Academy at Rajgir has made an app to convert the old sections of IPC, CRPC and Evidence Act into the new BNS, BNSS and the Sakshi Adhiniyam. It was been very refreshing in my own WhatsApp group of IPS officers to have this from Bihar. It's a really wonderful thing, sir. Thank you so much for your presentation also. The session of DGP sir today has been an acknowledgement of the work done to tone up Bihar police for technology-driven investigation and policing with emphasis to meet the challenges of the new criminal major acts. It has been his endeavor to acclimatize all of you to come over and to this new change. He has been advocating the importance of IVOs and has made it possible in Bihar police to have as many IVOs as possible with the present strength. A very great thank you to you, sir, for being such a good police chief who have propelled them to adopt to the new laws. I think Bihar is one of the states which have brought technology into policing in a very big way, and including the monitoring of the social media. The session of Honorable Justice Ananya Bandyopadhyay ma'am has taught about the provisions of the Bharatiya Sakshi Adhiniyam, which had less emphasis in the last session on 27 July. She has, in an elaborate and eloquent manner, given us the deep insights of the importance of digital and electronic evidence and the admissibility of digital evidence, which is as good as the documentary evidence we all dealt with till the new acts are in place. Ma'am has also told us about BNSS and the importance of the audio-visual evidence from crime scene to the trial. Lastly, I would like to thank the learned Advocate General P.K. Shahi sir for the undaunting support and guidance for organizing this workshop. I would also like to thank the Chief Secretary sir who had made his august presence today, and also the Development Commissioner under whose guidance as ACS Home, all the new initiatives what you see today have been formulated and thought of. I would also like to thank Arvind Chaudhary sir, the present Principal Secretary Home, who has reinforced great faith in Secretary Home Pranav and me to organize this workshop. And also like to thank all the DG rank officers for their participation. I would also like to thank the Patna District Administration, all the colleagues of present in Home Department, and also all of the technical staff, the IT team who has made this workshop possible. I'd also like to thank all the participants for the patient hearing and being a good audience. Hope you had a comfortable stay. Mahatma Gandhi said, there is a greater court than courts of justice, and that is the court of conscience. It supersedes all other courts. Hope you all work to make this possible. To conclude, I would like to quote from the great speech of I Have a Dream that Martin Luther King has said, which is a call for equality as a central theme of importance of everybody being treated equally. I quote, I have a dream that one day the rough places will be made plains and the crooked places will be made straight. Hope we all make this possible. This is our hope. This is the faith with which we will transform the criminal justice system in Bihar with the new major criminal acts to meet the needs and the challenges of the common man. Thank you all once again. Jai Hind. You may please try to have lunch and break off for the session, and the district officers can return to the districts. Thank you all again.
Thank you so much, ma'am. K. Suhita Anupam ma'am, Special Secretary, Home Department, Government of Bihar, for such a inspirational vote of thanks. Thank you so much. And with this, we end our 2 days workshop here. Thank you so much from the Department of Home and District Administration, Patna. आप सभी के लिए